Administrators, LLC, 2500534. Your appearances, please.
Good morning, Your Honor. Tony Blackman on behalf of the plaintiff, Active Life.
Good morning, Your Honor. Morgan Walters appearing on behalf of defendant Mackinac.
All right. Does anybody else have anything else that they want to say? If so, speak now or forever hold your peace.
No, thank you, Your Honor.
All right.
Good, Your Honor.
I got to tell you guys, I've read these cases more than I care to admit. I felt like I was studying for the bar exam in some ways. But anyway, here's defendant Mackinac administrator seeks summary disposition pursuant to MCR 2.116C10 on the claim of plaintiff Active Life Physical Therapy and Rehabilitation, Inc. for no-fault benefits. Plaintiff is the assignee of Eric Watkins and defendant is a servicing third-party administrator assigned by the Michigan Automobile Insurance Placement Facility / Michigan Assigned Claims Plan. On December 8, 23, claimant Watkins was involved in an automobile accident. He submitted an application for personal injury protection benefits to the MAIPF on December 18 of 23, seeking no-fault PIP benefits. He also submitted a claim for replacement household services per MCL 500.31071C, period. Replacement service sheets were filled out by two individuals, Stuart Mitchum and Bruce Botherod. Defendant asserts plaintiff is not entitled to no-fault benefits because claimant Watkins made significant misrepresentations regarding facts material to the claim for replacement services. Bruce Botherod testified during his deposition that he never assisted Mr. Watkins with chores. However, he did go on the scene. And this is on page 13 of his dep. I mean, I did basic chores and stuff like that, but I don't recall anything special. Watkins had been living with Botherod for a few months after the accident and was living with Watkins at his Utica Road address when the accident occurred. He stated, quotes, "I did the cooking, most of the cleaning. People just basically took care of their own stuff," end quotes. Mr. Botherod was shown the household replacement service form marked Exhibit A in his deposition. And when asked if it was his signature, he said, "I don't believe so. No," that's in quotes. When asked if he had any recollection filling out the document, he said, "I have no," quotes, "I have no idea what that is," end quotes. He said that that Watkins never offered to pay him for any of the services. Defendant argues that claimant knowingly presented false information in support of his claim for PIP benefits by submitting clear material misrepresentations in his claim for replacement household services in violation of MCL 500.3.173A, parents 4. In response, plaintiff argues that a genuine issue of material fact exists regarding whether any fraudulent act was committed in support of the claim for medical expenses, whether any alleged misrepresentation was material to plaintiff's claim, and whether a medical provider who is innocent can be denied compensation due to unrelated conduct of the claimant, here Mr. Watkins. The plaintiff cited Mills as well as Mills and City Express LLC, Mercy Transport, and Detroit Anesthesia Group PLLC as intervening plaintiffs versus Titan Insurance Company. The court would note that it is an unpublished opinion decided on August 8, 2017. There, the Court of Appeals affirmed the trial court's ruling dismissing the attendant care claims of the plaintiff based on fraudulent conduct, but which also declined to dismiss the claims of the intervening plaintiffs. Here, plaintiff argues the misrepresentation of claimant, if true, was actually $420 worth of replacement services only, so it is not material and therefore cannot constitute fraudulent conduct. Defendant cites, among other cases, Infinite Physical Therapy versus Nationwide, also an unpublished opinion decided on July 18, 24. There, the trial court had ruled as a matter of law that claimant was the owner of the individual vehicle and was not entitled to PIP benefits because he was uninsured. The service provider's claim for benefits against defendant insurer was dismissed but that's entirely different as far as I can see than this case. That result makes perfect sense. It would be unjust to permit the claims of a service provider to continue against an insurer where the claimant was not entitled to any PIP benefits because he was an uninsured owner and therefore ineligible for benefits. In Shelton versus Auto Owners, 318 Mishap 648, defendant asserted Shelton made fraudulent statements concerning her need for replacement services and therefore was excluded by the policy from all PIP benefits. The trial court granted summary disposition in favor of defendant as to replacement services, a ruling which she did not appeal. The court denied the motion as to payment for medical services. Defendant appealed that ruling and the Court of Appeals affirmed. The court analyzed the contractual language in the insurance policy, and the court concluded that the plaintiff was not subject to the policy because his right to PIP benefits arose by statute as opposed to the policy language in that insurance contract, which stated, quotes, "We will not cover any person seeking coverage under the policy who has made fraudulent statements or engaged in fraudulent conduct with respect to procurement of the policy as to any occurrence," and they emphasize the word occurrence, "for which coverage is sought." In this case, the court finds that at a minimum, a genuine issue of fact exists as to whether a fraud occurred and whether Watkins participated in that fraud. There being a factual issue, I'm going to deny the motion, and I don't mind telling you, I'm not only doing it on that basis, I'm not entirely convinced that the service provider's claims fall where there's a fraud by a claimant. And I've read these and distinguished these in my own brain. So I'm denying the motion. I'll ask you to prepare an order, Mr. Blackburn. Now, we can do one of two things. I'm going to leave it up to you two. You can either, how much is this claim for, Mr. Blackburn?
After the fee schedule adjustment, $4,400.
Why don't we, I'll give you guys a choice. If you want to file motions in limine and then have a settlement conference and do whatever else, I'll be glad to let you do that. If either one of you want to do that, that's fine. If it's only $4,400, maybe we can just do a settlement conference. I'll set it up now for sometime this week. Over $4,400, unless you want to come here, you didn't have to come here. We'll do it on Zoom. I'll put you in breakout rooms and I'll do it this way for you. So you guys tell me your preference. This is really, in my view, an interesting issue. I feel like I could make a case, whatever. Anyway, you guys want to do that, or you want to file your motions in limine and go the whole 9 yards? It's up to you.
I'll defer to defense counsel.
I'm fine with us just doing a settlement conference over Zoom, Your Honor.
Okay, so let me just ask a couple questions here. Lisa or Jeff, I'm sorry, can you put Jennifer on there?
I'm on, Judge.
Oh, well, who do I have? I don't know if I'm available this afternoon. I have no idea what I have.
Okay, well, we do have currently a settlement conference scheduled November 3rd.
I know.
Okay.
I don't want to make them, no.
Okay.
Yeah. Am I available at say 1:30, 1:45? And if so, are you two?
I am not, Your Honor.
Okay, that's good. That's fine.
Got
Let's talk about, what do I have tomorrow afternoon? I've got,
You've got trial tomorrow afternoon. Yep.
Okay. What about Wednesday afternoon? I've got severity court.
And a trial.
Oh.
And then
Great.
Thursday afternoon, you have an evidentiary hearing.
I'm sorry, I wasn't on here. I've got a trial on Wednesday?
Yes.
Is that, what time?
1. And then you have.
What case is
sobriety
that?
court. It's William Brush. Looks like a Woodhaven case.
What about Friday morning? Are you guys available Friday morning?
You're open Friday morning.
I am.
We are not available Friday morning, Your Honor.
You know what? Let's just do it on the 3rd. You guys don't have to file anything. I'll move the trial for you. Okay, it's not that old of a case. How many months is this, Jen?
Let me pull it up really quick. And trial right now is the 24th.
I know.
Okay.
So let's do it on Monday. What time was I going to do that with them?
Monday, the 3rd.
At 8:30, Your Honor.
Okay, let's
Yeah.
make it at 8:30 sharp, and I'll do it then. Just have your clients available by phone. I might ask them to Zoom, your client to Zoom in. But we'll just have them available by phone. I'll see you guys next Monday. Prepare the order if you would, Mr. Blackburn. Thank you both.
Will do.
Thank you, Your Honor. Have a good day.
Morgan. I'll take-
Thanks. What else do I have? What happened to the rest of these? Just here. Can I real quick take Kraft? Stephanie Marie Kraft, 25T64489, please. Good morning, ma'am. How are you?
Yeah.
Pretty good. You got to come and talk to me next time before the due date, okay?
Yes.
What do you need here? How many days do you need? What do you need?
New job.
You don't have to tell me any of that. Just tell me how much you can afford to pay and starting.
I can give you 25 today, and then I get paid November 6th. From then, and I'll get paid weekly. So if I pay 25 today, and then whatever, I'll have it done.
Just tell me how much you can afford to pay per week. Starting November 6th.
60, 65.
A week?
Yeah.
You sure?
Yes, I'll be getting paid. So I don't have to. I definitely want to do that this time.
Telling you, these pens here are worthless. All right, you pay 25 today and then 60 per week. Beginning November 10th, okay?
Okay, perfect.
If you need more time, just come and talk to me on it before due date, okay?
Okay.
Thank you. Diane Marie Sturgill. Can you give me a pen down there? You know what I get? That's one thing they did for you. Diane Marie Sturgill, 25W836-193. Thank you.
You're welcome.
Take it easy.
Morning, Your Honor. It's Yellow here. Along with co-counsel, we got it told.
Ma'am, your name? All right, so I have a charge here, possession of controlled substances. She was positive for a cocaine metabolite allegedly with regard to a test of October 2. What is she going to do here?
You need her plead guilty. May I present to you a confidential analysis that she's seeing there are underlying issues. She reached the finish line and then ran backwards, Judge. She was near the end of getting off of this charge, and there are underlying issues where she sought the support. It has nothing to do with an addiction.
I understand. Call Jessica.
May I present this to
You can. Ma'am, do you understand what your lawyer has said?
Yes.
You are here on a first technical violation. If you plead guilty or if you're found guilty here, you could be incarcerated for a period of 5 days. Do you understand that? And did you sign, read, and understand an advice of rights form?
Yes.
If you plead guilty, you will be giving up all those rights and there will be no hearing. Do you understand that? Did you file an appearance post-judgment?
think of you last week.
Okay, good enough. All right, so this is how you wish to proceed, correct, ma'am? You understand if you plead guilty, you're giving up all those rights?
Yes.
All right, to the charge that you failed to refrain from consuming alcohol or drugs, testing positive for a cocaine metabolite on a test of October 2 of 25. How do you plead?
Yes.
Did you in fact consume cocaine, say, within the 10 days before that?
How many days? How many days?
3.
Okay, but it was within 10 days of October 2, right? And you consumed cocaine knowingly, correct? Anybody force you to plead guilty?
No.
All right, I'm gonna accept your plea, find it to be an accurate plea, made voluntarily and understandingly. Mr. Zomick, give me 1 second, let me look at this. Your name?
Just go on.
Tell me what her issue was. What prompted this? This is bad. You got to get away from cocaine. That's bad stuff, right? What was it, Mr. Zomick? Under what circumstances?
She was convinced to use cocaine by until she went out with it that evening. It relates to a previous issue she had that she didn't raise her probation when she was something for sentencing, and it's something she'd rather not reveal and open the court to on her that has traumatized her. And this fellow talked her into it and she got caught. She's owned up to it.
She was ready to,
I sent her to a new therapist trying to address what I think are ancillary issues, not just the use of cocaine or narcotics.
did I? So she was sentenced on April the 2nd of 25. Right?
That's what I have, yeah, April 2nd of 2025.
How often is she testing?
Right now, she's testing on twice monthly.
And when is she scheduled to have her testing decreased further?
Testing is supposed to be decreased to once monthly beginning next month, November 10th.
Ma'am, is there anything you would like to say?
I just want to apologize for disappointing, you and also my family. And I'm also disappointed in myself because I was doing really good and I shouldn't have let it, the pressure, I guess, get to me. And I just hope that you can consider that too, please. Thank you.
All right. Can I hand you this document? It's from Counseling Therapy Associates. I just want you to take a look at that, and if you tell me if you have anything else that you'd like to say, after you take your time.
No, this is good. I mean, if she's compliant otherwise, Judge,
I understand.
she was very honest about her youth, was very honest about the mistake. I had no issues with her previously. Everything else is completed. She did have days on the SoberLink device she completed. She was at weekly testing prior, appeared to every test, never missed a test. It was negative for all of them except this most recent one. She was in outpatient services substance abuse. She technically did complete that. I'm glad to see that she's now re-enrolled. I think that's a good idea for her to get re-enrolled in substance abuse treatment. Victims impact panels completed and all 48 hours of community service are done.
Good. Anything else over here? What you want to say?
Just want to let you know, there's a corollary counseling that she's seeking along with substance use.
Good. Pay additional, I'm going to keep you on probation. Pay additional costs of $100. Serve 1 day on the court work program and pay $35 for that. Test weekly for 2 months. And if you're clean, I'll make it bi-weekly then for 4 months, and then I'll revert it to monthly. Defendant to attend treatment. Can you just give me the initials of that place?
CTA.
CTA. Okay? I wish you well.
Thank you.
Can you pay that today?
Yes.
Don't do this again, okay?
You guys see me something going on.
Well, I hope she's still, at some point, we're not. Thank you.
Thanks a lot. Have a good day. Thank you. Cook Thomason, Jason Michael Cook Thomason, 24B146297A. When I get to the civil infractions, I'm going to ask some of you to come up and have a seat at the table. Okay, just so we can move along a little bit. Your name?
Jason Michael.
You're charged with, you're on probation and you're charged with failure to attend a complete decision-based driving program, level 2 with Class A training, and failure to pay fines and costs of $888. Those are the charges. If you have one technical violation previously, if you plead guilty or if you are found guilty of either one of these or both of these, you could be incarcerated as follows. If you have 2 violations as a result of this show cause plus the one prior, you could get 15 days. If you're not convicted of any one of these, I'm going to dismiss it. If you're convicted of one of these, then you could get 10 days. So you get 5 days. You could get 5 days for each technical violation. Do you understand that?
Yes, sir.
Did you sign the advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to an attorney. Be happy to provide you with one at public expense. Would you like an attorney?
No, sir.
All right. as the count one that you failed to register, attend and complete the decision-based driving program level 2. How do you plead?
Guilty, sir.
Calling number one. Did you fail to register for, attend and complete the decision-based driving program?
Yes, sir.
Was the count 2?
I'm sorry, sir, what?
As the count 2 that you failed to pay your fines and costs is ordered, the balance owing at the show cause time being $888, how do you plead? Just give me 1 second. Did you fail to pay your fines and costs?
On the schedule, sir, yes.
Anybody forced you to plead guilty?
No, sir. You don't want.
Why didn't you attend that program?
So,
You've been on probation for what? How long?
so you.
13 months, right?
No, I haven't been on the whole 13 months.
I think I put you on probation September of 24.
So,
Well, that's 13 months. Your name? Why didn't you attend? Why didn't you do that? This was kind of a serious charge here.
so even schedule the appointment, you have to pay for it. That's my issue right now.
Where do you work?
So I'm a contractor and, just recently, so my fiance, we have 2 incomes in our house and for the last 6 months, it's just been me. And we're behind on all of it. Every single one.
Was she working until 6 months ago?
Yes.
That took you to 7 months into probation. Why didn't you register for the program in the beginning?
Sorry, they're still struggling.
How much do you make?
$20 a month.
Why didn't you come and talk to me? Did I tell you, or were you the one that I forgot last year to tell that you come talk to me if you don't have the money to pay? Didn't I tell you that?
Yes.
Of course I did. Why didn't you come and talk to me?
That is my mistake. No, I apologize.
What do you have to say? Anything?
I'm aware of the financial situation. I've done my best to work with him. We're running out of time. He did complete his court work program and his community service. But it is true, you have to pay to register.
I'm not discharging you from probation until you do this.
That's understandable.
I don't know why you wouldn't come and talk to me like I offer. Why didn't you come and talk to me? I don't get that. I don't understand that. Nobody's going to allow me to give me any reason that will cause me to understand that. Not when the judge tells you, you don't have the money, no problem, call the court, we'll go on Zoom, I'll give you an extension. Right?
You're right. And then
Thank you. I mean, you got out of this relatively unscathed. How long of a program? How many sessions is that again? Remind me.
I believe they do it in the weekend. It's 8 hours, so yeah, they must do like a Saturday, Sunday.
You're to pay additional costs. Did I let you finish? Anything else? Pay additional costs of 75. Pay additional probation fees of 60. I'm extending your probation by 3 months until March 11th, 26. You're to serve a day on the court work program, and you're to pay $35 for that. You're to complete the program no later than December the 31 of 25. Okay? I'll let probation set up the rest of the terms of the payment. Did you graduate?
Yes.
Maybe you need to find another job. I don't know what to tell you. Probation to set up terms of payment. You got a minute to sit with him? Good enough. That's what we're gonna do. And now you can incorporate those into the payments, all right? Thank you. People against, do I have some video on this?
Sure. That can be found in the.
Mr. Haynes is waiting after this too.
Jamie Lenore Pratt. 23WA32353A and B. Good morning.
Good morning, Judge. You have it to go P82378 on behalf of Mr. Pratt. Mr. Pratt, state your name for the report.
You have to start your video, ma'am.
Pratt, Jamie Pratt.
What do you think I'm thinking?
She stands mute and waves reading, Your Honor.
Did she just, hang on, ma'am? I don't know where you are. You're gonna have to stop. I need to see you. You're not driving, right?
No,
You're just-
I'm not driving. I'm stable.
Where has she been? Where has she been? She just called up today, Lisa, said cancel the warrant. I want to go in front of the judge when she was supposed to be here. This case been going on since 23, Ms. Pratt.
Okay.
All right? It's way too old for me.
It's just a warrant. Everything that the case was about, I did the first ticket. I have my license. It's just a warrant that's holding me up. Anything that's involved in this case has been done.
It's just a warrant. Is that what you said?
It's just a warrant. That's the only thing that has to be there. I have my license are valid. That I don't even have that car, but I got the headlight fixed like within the week of me getting the ticket. I did not know I had to bring it back to Woodhaven.
Ma'am, I'd suggest that you at least acknowledge. I know it's impossible for some people to say.
Acknowledge what? That I got the ticket? I did get the ticket. My headlight was out. My license was suspended. I'm not denying that. And I've done everything to correct that.
Give her a new date. We're going to give her a new date for an arraignment and pretrial. Defendant has to appear in person.
I'm not upset, but that's not going to be able to happen.
Well, then you're going to have a warrant issued for your arrest again, okay? You're going to have a warrant issued for your arrest again.
Because I can't come into the courts? Because I'm in another state?
I don't want to, listen, I don't want to do anything to inconvenience you here. I don't want to inconvenience you.
This is why.
Give her an in-person date. I'm not going to play this game.
Me either. November
In-person
12th at
deal.
8. She's gone, Judge.
Good. November 12th at what?
November 12th at 8:30.
What an attitude. What an attitude. Case is outstanding since 23, and it's just a warrant. So she stood mute on both. I'm giving her a new date. She didn't allow me to set the bond. I'll set the bond when she comes in, okay? So November 11th. Wow. November 12th at 8:30. Jeez, what is happening? Huh? Can you tell me what's happening?
No, Judge.
I don't want to know. I don't want to know. I don't. Godfrey,
Thank you, Judge.
Richard J. Godfrey, 25F244515. Good morning, Mr. Haynes.
It's tough on the follow.
Yeah, I know. Well, maybe he's going to yell at me too. You never know. Of course, they're not as brave when they're in person, are they? Your name, sir? Richard Godfrey. All right, so Mr. Godfrey here, we adjourned the sentence. What happened is, well, let's back it up. He pled guilty on September 29th, the failure to submit. September 16th and 18th. And now I've got, calling Jessica, I've got failed to submit the biweekly testing, which was ordered on September 16th. And failure to submit the biweekly testing is ordered on September 18th. So,
So he had already pled guilty to those.
right,
Returned to the seven.
I know. So I'm going to get Ms. O'Donnell in here. Has he been testing since then? Do you know?
No. So the issue was a matter of, I guess what we call shy bladder syndrome.
Did he go and get a medical excuse?
Well, he went to the doctor. He said the doctor refused to give him that authorization.
Basically looks at me and said, no, I'm not going to do that, and walked out of the room. Yeah, he explained the whole situation to him, and he said, no.
Did we talk about this with possibility of a pat-down search? Did we talk about that?
Well, what,
A pat-down before he tests?
we didn't talk.
If you don't have a medical document that tells me you have shy bladder syndrome, I can't conclude that you have shy bladder syndrome. Listen, please.
I understand that.
The idea that you're not going to test is not good. It's not going to happen. Hang on. It's not going to happen. I'm just telling you it's not going to happen. You called Jessica, right?
Yeah, shut him up.
How many other tests has he missed since then? Or not tested?
I don't know what this schedule is. That was 4 weeks ago, roughly.
All right.
Just hold on.
He didn't test.
So he did appear for testing. He appeared for testing on October 16th. He tried and he again was a CNU on that day.
You can't pee in front of
Gotta
you.
figure it out.
You can't pee in front of somebody, urinate in front of somebody. Is that the issue?
If you cut close, you got 30 seconds.
Listen,
Yeah, no, I can't. If there's somebody not standing there, I still couldn't do it. I've had that problem my whole life. Told you. My wife, please.
is DNA open today?
I don't, can't, you're on.
Sir, you're going to have to test. You're going to have to test. Even though there's no shy bladder syndrome, and I always require a diagnosis of that for a pat-down,
Yes.
defendant to test today or first available day. Defendant permitted to have pat-down search before testing.
So like them to allow him to just like give him more time because even with the patent on the.
Yes, I mean, tell them, be reasonable. I find it hard to believe that they're not being reasonable. He's like the only one that's come in here and said gave you 30 seconds. I mean, I can only tell you if I don't have a test, it's not gonna be nice. I'm giving you every benefit of the doubt here.
I understand that.
I'm giving you every benefit of the doubt there. I'll underline it, bold it. That's what's happening. You got to test, period. If not, you're going to have to go do blood work and you're not going to be able to afford that. I'm telling you. How much is a blood draw?
Honestly,
Ridiculous. A couple $100.
it's over $100.
It's more than that. So we'll adjourn the sentence. Hang on, John, I'm sorry. Adjourn the sentence about a week out or 10 days out, or when Mr. Haynes is here again, Lisa. You got to test. Okay? I know what's going to happen.
Couple days, so I'm doing.
I know what's going to happen. You're going to come back here and you're going to test positive.
That's not.
Okay, good. Then we'll all be happy.
What, 76 days?
Good. Lisa, yeah, you got it. When are you available?
Judge, I've got arraignments next week on the 3rd, and then I'm doing all the on the 13th.
You think we can get that test?
Yeah.
Not sure.
By the 3rd, I mean.
Yes, he can be able to test this week.
By the 3rd, we'll adjourn it to the 3rd at 8:30. Is that good?
That's fine.
Okay. Adjourn it. Is that good, Lisa?
Yeah, that's good.
Good. Go talk to her. Thank you. She'll tell you when they're tested. All right. Now I'm going to try to move you guys out of here. My sincere apology. So we're going to move these out rather quickly. First of all, I want Nathan Michael Porter up here, 25T646-474 A and B. Could I have seated up here Amanda Miller? Your name, sir?
Nathan Porter?
All right, so you're going to plead to no proof of registration. That's on file A. And they're going to dismiss the no proof of insurance, right? All right, to that charge of no proof of registration, responsible or not responsible?
Spells.
Is that what you're going to do, is plead responsible to that?
Can you please restate that? Sorry.
Yeah, this tells me the stip form that you're going to plead responsible, admit responsibility to no proof of registration with the understanding the expired plate and no proof of insurance will be dismissed. Is that your understanding?
Correct, yes.
So to the charge of no proof of registration, how do you plead, responsible or not responsible?
Responsible.
Plea is accepted, original charge dismissed. That's the expired plate and no proof of insurance. 135, you can go right down the hall and take care of that. You're all set. Good luck. Thank you. Amanda Miller, Amanda Jill Miller, 25W840024. Good morning. Your name, ma'am? All right, so you're going to plead to impeding, right? You're going to plead to impeding traffic, correct?
Yeah.
Is that what you want to do?
Yeah.
To that charge, responsible or not responsible?
Responsible.
Okay, I'll accept your plea, dismiss the speed 150, and you're all set. Have a good day. All right, now, Palmer, Rosie LaShawn Palmer, 24W834225A and B. Your name? I have to arraign you on this unless you tell me you have the money. You have the money on these? You owe 248 and 362, which should be 610. Why are you waiting so long?
Well, nursing school in Ohio, and then so I have to pay gas money to my friend protect me, and then I was at work on
This ticket's been outstanding since April of 24.
I've been in school since
Where do you work?
Children's Hospital.
What do you do there?
I'm a school nurse extern, so my hours are limited.
I'll give you one more chance, but you can't do this again, okay? You can't ignore courts like this. You were supposed to be here for a show cause in August of 24.
Oh, I didn't receive that.
All right, you pay $100 now on that case, and then you're going to set up your own payment plan. How great a country is this? Well, how much can you afford to pay weekly or bi-weekly?
$50 weekly.
You sure?
Yes, my mom says she can help.
All right, we're starting when?
The 31st. That's what I'm paying.
All right, I'll make it November 3rd. You pay 100 now, then 50 weekly beginning November 3rd. That's on the A file, and then same thing on the B file if you can set her up and give her a plan then. Okay, Lisa? So we'll string that out. Listen to me. If you don't have the money next time, you call the court, we'll go on Zoom, or you walk in here on or before any of your due dates. I'll be glad to give you an extension, but you can't ignore courts like this. It never looks good. You understand?
Yes.
All right, best of luck. Christian Cornelius Stringer, 25T646470. Can I have seated at that table up here then? Darlene Barnard and Mansour Issa. Good morning, sir. Your name?
Christian Stringer.
You're 21? 20, sure. 20.
21 next month.
You know what drives me crazy when I'm going down the road? Watching people operate while texting. Don't do that. You're going to hurt yourself or somebody else. You're going to plead to impeding, right? Responsible or not responsible to that?
Responsible.
All right. 180. Okay? Original charge dismissed. Don't be doing that. I'm telling you. I can't believe people do that still all over the road. Darlene K. Barnard, 5T646-464 5. Good morning, ma'am. Your name? All right, you're going to plead to impeding traffic, right?
Yes.
How are you? I haven't seen you in a long time. You doing all right? To that charge, impeding, responsible or not responsible? Please accepted. Original charge dismissed. 150. Cashier into the hall to your right. Thank you. Mansur Naji Issa. 25T646438. Could I have, is Issa out there? Mansur Issa? Is Mansur Issa out there? Can you bring him in? Glenn Thomas Loop. 25W839714. He must be out in the hallway or. Okay, your name? All right, so you're going to plead impeding traffic, true?
True.
To that charge, responsible or not responsible? All right, I'll accept the plea. 155 is your total. Cashier into the hall to your right. Good luck.
Thank you.
Kaylee Marie Gorecki. 25B149492. And could I have up here Caitlin Vieira and Robert Poma, please? Your name, ma'am?
Okay, Marcus.
No injuries, minor damage. You're going to plead to impeding, right? Responsible or not responsible? I'll accept the plea, dismiss the original charge, 195. Cashier into the hall. Be careful, okay? Thank you. Caitlin Lindsay Vieira, 25B149587. Good morning. Your name? So you're going to plead the expired plate?
Yes.
Responsible or not responsible? Please accept. Do you have a valid registration now?
Yes.
Do you have it with you?
Yes.
Can I see it?
Can I run in my car to grab it?
No, I'll take you at your word. 115.
Thank
you. You're going to plead to that charge responsible, expired plate? Oh, I'll make it 150. I'll take you at your word. Good luck.
Thank you.
Robert Lee Poma, 25B149595. Your name, sir? All right. Good morning to you. You're going to plead to impeding traffic, correct? Responsible or not responsible? All right, 150, original charge dismissed, please accepted to impeding. You're all set. Good luck. Damian Stephen Tomov, 25B149199. Mr. Tomov, good morning.
Good morning.
Your name?
Tommy Tomov.
What do you do for a living?
I work for City One.
I mean, it's just, you look good. Came with a tie on.
Came for occasion.
What's that?
I said came for occasion.
You're going to plead to impeding, right?
Correct.
Responsible or not responsible?
Spot.
All right. All right. 160 is your total. Cashier into the hall to your right. Original charge dismissed. Amanda Dawn Igna. You too, thanks. 25B149457. I need Willie Deal seated at the table and Samantha Bricker. Your name, ma'am?
I'm in the egg.
All right. This has to go back to the officer. Can you have a seat right behind you, please? Thanks. Tell John to take that to Du Bois. Willie Clifton Deal. 25F244438.
You see?
No, you can come right up to the podium there. Your name? All right. You got to be careful. I'm not even sure you deserve impeding here. You understand what I'm telling you?
Yes.
What are you why are you operating and texting? I mean, is there not enough advertising campaigns over that? I mean, I can't believe it. Why are you doing that?
Yeah, I was working at Curry. Had a moving company right on flat. I was looking at a canvas and I was navigating. I was reaching on my windshield to take my.
To the charge of impeding traffic, how do you plead? Responsible or not responsible? Don't come back and ask me for one of these again, okay? You got a not so good record. This is your second one of these. Went into default. I'll set aside the default judgment, 245. Just go down the hall and sign that bond over and you're all set, please. No more of that.
Okay, it should be a point for that too, because I missed my court date. Yeah.
So we're gonna take it off. Conviction will be taken off the record.
How long does that take to start the report to my insurance company? So they can decrease them.
I'm doing it right now, Judge.
They're gonna do it today, right now, yeah.
It's coming off today. Thank you, John. Appreciate it.
Go sign your bond over. No more of that, please. Thank you.
Well,
Did anybody locate Mansur Issa?
He's not on Zoom.
Samantha Diane Bricker, 25T646645. Good morning to you. Your name? All right. So you were going to plead to impeding traffic, right? Responsible or not responsible to that? All right. Please accepted 160. You're upset. Cash, you're into the hall to your right. Good luck. Yeah, how long?
60 days.
Where do you work? Give me that. I need her file, John.
I work for the branding solution,
I'm sorry?
Halo Branding Solution. But I just went back to work 2 weeks ago.
That's a lot. You're asking me for a lot. Do you have a husband, married, or kids?
She just went back to work from maternity leave and became a single mom in that
Okay.
4 weeks.
All right, good enough. Good enough. Can you pay $30 per week starting in about a month?
Yeah.
You pay $30 due each week, beginning on November. I'll make it November 24. Listen to me very carefully. If you don't have the money, no problem. Call the court. We'll go on Zoom and give you an extension, okay?
Thank you.
All right, or you can come in here on or before your due date. Just on or before your due date, all right? Thanks. Mansur Issa in here?
I checked outside, your honor's not out there.
Lisa, I think we're just going to reschedule this. I don't know why he thought he could leave or. But I don't see him in here. I've called his name multiple times. John called his name in the. So I'm simply going to say. Defendant, reschedule. Defendant must have left. If you see Bernard's, ask him if he knows who he is.
Okay.
Albon Jetta, 25T646491. Did you take this young lady's file to Mr. Dubois? Your name?
Jedi.
Listen, your record looks bad. What are you texting and driving for? Just tell me. For the charge impeding traffic, responsible or not responsible? Responsible. $200, please accept it. Stop it, okay, please, thank you. Tamulaloa Botima, right, 25W839663. I'm sorry if I mispronounced that. It's TEMILOLUWA.
He's on Zoom.
Okay, right. All right, good enough. 25W839663. Your name, sir?
My name is Timmy Wright.
All right, you want to have a hearing?
Yes, based on
He's got you going 83, he says, in a posted 70. I'm just asking. You want a hearing? I'll give you a hearing. I could care less.
The officer I spoke to just now, we had talked about possibly speaking directly with the officer that issued the ticket.
Give me an informal hearing date, Lisa.
November 6th at 9:30.
November 6th at 9:30, okay? November 6th at 9:30 will be your court date. All right?
Can I ask, just to confirm, this is Eastern time, correct?
Yes, sir. Where do you live? Oh, you live in Ontario.
It's Alberta, actually.
Okay, okay. All right.
All right.
Okay.
Thanks so much.
Have a good day. We'll see you here then. Thank you. John James Schaefer, 25F244726. Your name?
John Schaefer.
All right, so you're going to plead to no proof and you want time to pay, right? To the charge, no proof of insurance, responsible or not responsible?
Responsible, sir.
Plea is accepted. Do you have insurance now?
No, not yet. I just got a new job, so I was gonna ask you to wait a week, possibly two.
I don't have a problem with that. You can't drive without insurance. You get yourself in all kinds of trouble. You know what I mean?
I've noticed.
How much, so your total here is going to be 185. Tell me how much you can afford to pay.
I just started the job. I don't know if they hold my first check, so I was gonna ask them for 14 days and I'll pay the whole sum.
I'll tell you what, I'll just give you until November the 20th to pay it in full. How's that?
That's amazing, sir. Thank you.
If you need more time because you don't have the money, you call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you very much, sir. Have a great day.
You too. Thanks a lot. Damian Lee Edwards, 25W8400083. Do you have that? I think that you need to tell me whether there's injuries or.
Yeah, that's what I knew that was a mistake. I just didn't know if
Okay.
there was an impeding traffic that was already, issued in the past or not. That's what I'm trouble reading right here.
Yeah, all I need to know is if there was injuries or serious damage.
No injuries, minor damage.
Okay. Your name, sir?
Game over.
Good morning to you. You're going to plead to impeding traffic, right?
Yes, sir.
And then they're going to dismiss the speed, right?
Mhm.
Yes?
Yes, sir.
All right, this is a commercial motor vehicle, right?
Yes, sir.
Charge impeding traffic, responsible or not responsible?
Possible.
All right, 180 is your total. Cashier under the hall. You're all set. Good luck.
Thank you. Have a good day.
You're welcome. Joshua Evan Worthy, 25W838369. Good morning, sir. Your name? So you're going to plead to minor damage, no injuries, would include impeding traffic, right? Responsible and not responsible. Plea is accepted. Initial charge to
timestamps as far as the police report are concerned. And so I think Jimmy's the second or third person to have this. And so I don't know that I've ever talked to him directly about it. I think this used to be Sonny's case.
Sometime before the trial date would be a good time.
Typically it would be.
I mean, you've been on this a while. It's 500 days old. Come on.
I've talked to several people in the DA's office
the
about
prosecutor handling the, you know, how it passes on, and they ought to pass that information on and note it.
I think that'd be a.
But you got to still, you know, talk to them directly, and they're friendly. Sometimes. Odd days, the odd days. So they're even an odd day.
Your Honor, this is the first I've heard about that. I can investigate that at this stage. The state is ready to go on and make the rest at this point.
He's never heard about it before with him.
Your Honor, I inherited this case from Mr. Eckhart. So that's the only reason why.
But not on the day. Everybody,
yes,
sir. I used to do this sort of thing, and I wouldn't. I mean, you have a problem on trial docket is.
Well, frankly, we could go right now, but you know, it's going to involve an exclusion issue. So I'm ready.
Yeah, an exclusion issue that you're bringing up to me 15 minutes into the trial docket on the day we were going to pick a jury. You don't think that's untimely?
I believe it's been addressed with you as well. I have to get the transcript from prior hearing.
Let's just, the lawyers are the ones that are the advocates, not me. Y'all got to move y'all got to move it. I'm getting it before me so I can be heard. We only get 2,500 cases a year. I don't bring them home, read them. I got to rely on you. What's state going to do today?
Judge, I'm ready to proceed on evading. At this stage, that's the state's announcement.
Fence is ready.
All right. How long do you think to take on evading?
It's a short call, Judge.
Short trial. And is the defendant eligible for probation?
No.
No. All right. All right. And Coy died. Title bond. Coy died.
Mr. Nair tells me that they're working on a resolution. Mr. Blah is about to get the family involved in negotiation.
Is that going to be done today, they think?
Sir.
Are they planning to do that today?
They're working on it for today, yes, sir.
Malachi Harris?
Mr. LaFont made the same thing.
Huh? I didn't hear.
Malachi Harris.
Yeah, I'm ready. I can go.
I don't have a DA on that.
I'm uncertain, Judge. Malachi Harris.
Does any one of the district attorneys want to volunteer on that one? It just says DA. It doesn't say anybody in particular.
I had Sonny with it the last time.
Okay.
I think it went from Sonny to Ms. Staub, and now it's unknown. So I'll know it's ready. I can try that, Kel.
Actually,
That's fine.
what I gathered from the district attorney's office is those two previous people are no longer here. I think y'all might be afraid to pick it. You bet the curse is now on you.
Oh,
All right.
ready.
Gutsy move, Jimmy. Gutsy.
Yes, sir.
Yours. So, Mr. Ham is.
Yeah, that's fine. I'm ready to go. I'm ready to go. We can try to finish first.
Jerome Ned.
Yeah.
That's Joe. And is that yours?
Yes, Your Honor.
No, who's the DA on that? It says DA again. The anonymous prosecution.
Judge, I got an email from the court a while back saying the complaining witness was deceased.
From the court? Why would I send that?
Does he damage to the vehicle?
Why would I?
Maybe it wasn't the court, but I got an email from me.
Look, I don't see anything. Look, that would not make sense for us, but if we knew about it, we would tell the parties, of course, but there's nothing formal in this file that shows I've sent a missive to any of the parties. We just send notices. There's no letter, and I would have probably formalized it. But it's a injury to a child, third-degree felony with a prior conviction alleged. So there.
It's actually the elderly persons.
And then it says, yeah, injury to a child or elderly. $79 years old. I'm sorry. 80 now. That's the victim. Well, what do we think?
I guess we're ready.
Yes, we're ready. All right.
Judge, this is another one of those. It was Sonny went to Sarah, and now it's unknown. I'll step in and handle it as far as.
Where is Mr. Ned? Is he in custody?
Yes, yeah. Sorry, I'm going to custody involved.
He's in custody, yes.
I think this one is 80-year-old victim. This needs to move faster. Move fast. So can you find out, because it's a year-old now, can you find out where things are? Because this one might be a trial.
Yes, sir.
David Zarate, pro se. I'm going to go to Glover Jones, Kimber. Anything, what do you think about it? That's yours. Do you know anyone you can say?
Haven't heard from Mr. Kimler at all on that.
Something I don't know.
Well, no, he's usually pretty good about talking ahead of time.
Is he?
Yes, with me, he is just.
Let's go.
So. Okay, back to Zarate.
Yes, sir.
Who's on that one?
That's another one of those
Is
that
that, are you the lucky?
did the shuffle from Sunny to Sarah.
That's a indecency pro se. I'm thinking that probably is not the one that, because of the time, it's a fairly really newer case. So that one is going to get reset.
But the nature of that case, I can't step in and resolve it.
Okay, so I've got. What was it, Ricky Johnson that everybody had kind of geared up for? Yes?
Yes, sir. Yes, sir.
No? That one? Okay.
Yes.
First, that's Ryan, and we're going to do that one. And then Arnold is 2. Well, I wish I could try 2 at a time. On 3 is Derek Lewis. 4 is Senegal. And 5 is Marks. Washington is 6.
Number 1 in the book. This.
I just, I don't think we're going to get past that, but we may try to send.
No, sir. That's what we did.
Derek, Mr. Ham, if we may try to get Lewis to the drug court.
Yes, sir.
Their panel comes in tomorrow, Jed.
Their panel comes in tomorrow.
Yes, sir.
Okay.
Yes, sir.
There. Those. And do we have something that's being disposed of? You got it. Who is it?
The one I need to go talk to my client on is Clover, but I know you're going to call the second docket.
Yeah, but I'll plug you in anytime you're ready, when you're ready.
Okay.
Okay. Yeah. Okay, Daryl Albanese.
Ready. Let me.
You're leaving now?
No, I don't know. The album was.
You don't have to get in. Don't get in. It's awfully nice of you to do that. What are we going to do?
Hey, well, Mr. Albanese, since the office 15 months state jail, it's a death case, and he told me no to that.
Well, they all say no. I mean, who wants 15 months in a prison facility? I wouldn't know.
Judge, we're also confirming to see if there's a drug case coming down. We haven't received it yet. But when he was arrested on this, he was arrested on a drug case as well.
Okay. And what was it? What do y'all have on that?
There's not anything on our side of the file.
You don't have a return yet?
Not yet. I did just email up to intake to see, but I don't see anything that we have on it yet. I don't know if we're waiting on labs or we're not proceeding, or I'm not exactly sure what's going on with that.
All right, he's charged with a state jail felony. It looks like he's got 2 other state jail felonies. And does this enhance it to a 3rd-degree felony, these 2 priors?
That's correct, Judge.
Looking at up to 10 years in prison. The crystal-like substance weighing 1.3 grams. And we don't have a return on that yet?
No, sir. I don't see it in our system, so I don't know if we're waiting on labs, if we're proceeding. I'm just trying to get some more information at this point.
Go ahead. What did y'all want to say?
No.
He's here. You're Mr. Albanese, right?
Yeah, I had informed him of the.
Wait, who are you?
Mr. Albanese.
Okay, yes, Daryl.
No, I had informed him of the 15-month offer, but he was concerned about a new case possibly coming out.
I would be. That's a felony if it's, what is it, if it's a drug, you know, if it's, if it's methamphetamine, crystal meth, which is what was thinking it is. Do you have an idea when that might be returned back from the drug line?
I'm not sure. I sent an email up to intake. I can check later today to see.
Okay, but here, right now, they got an offer, they got 2 cases. What do you?
I just want a short reset, give them time to find out what's gonna happen with that other case.
2 weeks. Let's see what we do in 2 weeks.
Well, I'll have to go unagreed to the judge on that. He could possibly do that. But
Day before, I'll complete it again.
well, I don't have a problem doing that. We gotta wait to see what's gonna happen with that other case. Basically, what he's saying, he doesn't have a problem going unagreed. Just we want to see what's going to happen with that other case, and if not, we can go unagreed.
Can we try to get the lab to get it back to us in 2 weeks?
I can see just the status and figure out if it's the lab we're waiting
I'll
on.
reset 2 weeks. Okay, everybody. Thank you. That trick.
Yeah. What's the name?
Connor.
I have not seen.
Connor. Last name.
Oh, I'm sorry.
Yeah.
Look. On him, Judge, I don't have a client. I don't have a client on Mr. Connor.
Whoever the defense attorney would love to be able to say that. So
Judge, he does have 2 new cases in received status. I think we're just waiting on them to go to grand jury. So at this point,
okay, fill in the gap here. What's the deal? You're not, this isn't your case?
No. Well, I guess I misspoke. When I said I don't have a client, to my understanding, he shipped off to some other place, so it's not here.
Quindetric and Connor is not here? He did what?
CRE.
How do you spell that? I just wanted to test, just to see if everybody's listening to me or not.
Did I say it?
ACW, yeah.
ATW.
AT.
Absent without leave, probably. All the way.
That would be AWL. AWOL.
It does look like he was transferred to somewhere else. It doesn't say way as a fit.
So what are we going to do about getting him back? Since he's got 3 important cases.
Judge, I would request that we wait for his 2 new cases to.
Oh, there's 2 more coming?
Yes, they haven't gone to grand jury yet, but we do see those in our file. So I would request.
You may be able to walk out. Let's review it in 3 weeks, just 3 weeks, okay? All right, last time.
No, that's perfect.
Cody Garrett. That's 5 cases. You could move.
All 15 years.
Well, I mean. Let's see.
September 24th.
Yeah, you got 5. First degree felony for life, but 2nd degree for 20. Kidnapping, that's 3rd degree, that's 10. So we have life and 30. 3rd degree assault. Another 10. Yeah, this 3rd degree continuous violence against. So we got life. And
Michael.
and how many years? 1, 2, 3, 10 years. So life in 50 years is what we're looking at. On all this. Okay. What?
Judge, I did make an offer, Mr. Ham was recent offer of 15 years on all cases. And
together?
Right, I told him, do you want 15 years or no?
So nobody wants 15 years. Nobody wants 15 years, but What are we gonna do? Is he eligible for probation?
Yeah.
I'm just curious. I don't see any priors on those indictments.
He might be judge up. Too many irons in the fire.
Yeah, this is. Someone we have somebody not, who has not been through the system before and convicted with 5 different cases. April 18th must not have been a real good play. April 18th. And then April 18th. So 4 criminal cases fall down to the April 18th episode. And then a month before that, we had the first degree felony murder. Yeah. So life and
He's eligible.
50 years.
I don't show that he's got a felony conviction, Judge.
What do y'all want to do? One way or the other.
He's not accepting the offer. That's
Is that right?
so trial. Nature of these
Is that
things, the state will try one at a time.
You're refusing, is that right?
Right,
Is that what he's doing? He's refusing? Nobody wants that, but I mean, is it gonna make a deal or not?
The state is not never going to offer probation on this case. We'll try these cases one at a time until we get what we want.
What's he want to do?
All other options if they have.
Welcome.
And probation is to explore the opportunity to plead unagreed to the judge. But that's something that you can think about between now and.
What's he want to do?
I set it for trial.
Okay, then there is no deal. Okay, so there will not be a deal. We'll just handle these 5 times. Okay?
Perfect.
Good. That is the order of the court.
All right.
Okay, next is, what do I have next?
I got the sale. Can I have one reset on the door?
On the
Just
sound,
one. This is
everybody
my
listen.
first time putting this work together. With us. I think I got that with, I just want one reset, just one.
How long? 4 weeks?
4 weeks.
That's all you got? Okay.
That'll work.
Sound reset 4 weeks. Clemente Hernandez.
Finally, I'm talking to.
Yes, he doesn't speak any English. I want to talk with Ellie about getting reset. We could have an interpreter. Okay. I'm always said 3 and 4 weeks. Howard loves to take everything in turn. 3, 4 weeks.
I'm trying to be here.
Okay, reset 4 weeks. Natasha Laverne. Readiness to plead. Natasha Laverne, please. I need those files. Thank you. Natasha Laverne.
Yeah.
On Ashley Nelson, I'm looking ahead. That looks like that has been reset as we are still waiting on a medical report.
Yes, sir.
So we'll reset what, 2 weeks?
Yes, sir.
Thank you. On Ashley Nelson's 2 cases, 24 CR 1985, 1986.
On mine, I got it.
Deferred and filed. Come on up. You need to get fingerprinted over here, please. Fingerprinted right there. Thank you. 25 CR 1029 will be called.
Raise your right hand.
Natasha
What's up, you got?
Laverne.
Do say it.
Yeah.
You got your right thumb. Let's fly right there. The whole time, right here. Okay, so stand by the judge.
So you are here with Mr. Producer, your attorney and the state's attorney. You're Ms. Laverne? Yes?
Yes.
Okay. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes.
In summary, in this cause number 1029, in summary, this indictment states that on or about July 5th of this year, in Jefferson County, Texas, you committed the 2nd degree felony of robbery. Do you understand what you were charged with?
Yes.
If convicted, you face no less than 2 nor more than 20 years confinement in prison and fines Up to $10,000 can be assessed. Do you understand?
Yes.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, ordered to pay a fine of $500. Is there any restitution owed on this case? Any chance?
No, sure.
I'll check while you proceed, Judge.
Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this charge, ma'am? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will.
Yes.
And because you are guilty. I'll show you which mark this states Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney. The contents all correct?
Yes.
States Exhibit 1 is tendered in the without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes.
I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the second-degree robbery. But I'm going to defer or postpone any finding of guilt so long as you follow terms and conditions of probation. The probation officer is going to go over with you all of these. And this will be for a period of 10 years, but you do well, I can shorten it to 1/3 of that, 3 1/3 years. Again, there will be fined $500 and other terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow that. If you fail, your probation could be revoked. You could be then found guilty and sentenced up to 20 years in prison, which I don't think anybody wants.
I don't see where the items were recovered, Judge.
You don't see the what?
I don't see that the items were recovered. Whatever. 7 items paid at $300 a piece, so it looks like there's $2,100 worth of restitution. Sunglasses.
This 9 pair totaling for $3,000.
My report reflects 7 at $300 a piece.
What do you know about that? Defense.
Did they ever get the sunglasses back? Do you know? They did.
How did that happen? Keeping in mind, you don't want to mislead me because we'll get to the bottom of it. Don't mislead.
They got them back at the mall there.
Stuff whenever I want to miss them.
Okay.
You gave everything back?
Yes,
To the-
but they had that.
Okay.
Yeah.
And that it looks like it included several pairs of sunglasses from the store, right?
That looks good.
Okay. And all of those were given back to the police,
Yes, sir.
you're saying? Man,
It was found.
Yeah, just ask Kim. You see what she's, if she's saying I have something of it.
Okay. Excuse me, let me, we're in the middle of a plea hearing on this. Thank you. Sorry. All right, here we go. I'm sorry.
I don't want to.
We're not certain.
Yes, sir.
About this. The defendant says the police recovered all the items. The state does not see that in the report. I don't either. But can I do a tentative restitution order?
Yes.
And it either is paid back or the items are returned to satisfy the reimbursement. But how much is the restitution?
To me, the restitution should be $2,100, Judge. If in the event that these sunglasses were recovered, obviously that would diminish.
Yeah, the court is going to order restitution in the amount of $2,100. But if they are all returned back unscathed, that is in the same condition they were in. So when they were taken or stolen, anyway, you will be given credit for all of that. Do you understand? But we don't know for sure because there's a difference of opinion here. But if you have a problem with it, tell the probation office if you believe whatever occurs on that restitution is not what you understand, and then we'll have a hearing. But we're going to tentatively order restitution or the return of the sunglasses in the proper, in the condition they were in when they were taken. Okay. All right. Please see the probation officer. Thank you. Yeah. On Donna Arnold, 3 cases. Donna Arnold, 3 counts.
You will fight back because they'll do it to us.
Okay, so what are we doing today? This is my question. What do you want to do today? Yeah, I know what you want to do. What are you asking for? A hearing on this? All these things? Let me see what you're
Reinstate. Okay, let's be a little more specific. On September 16th, she failed a drug test in the courtroom. And that was after she had 5 failed drug patches. Your Honor revoked her bonds based upon those and ordered that there be no bond.
What are you asking for?
A bond.
Denied. I'm going to stand by the record on this. The court, it feels futile in trying to handle this without custody. We have tried at least 2 different methods and those have failed. She's still testing positive. So we'll set it for trial.
The problem
is that are we going to set it for trial, sir, or not?
Well, I'll talk to Mr. Ann about trying to.
All right, set for trial. Next is Terrence Limber.
If I could speak, Your Honor, the problem setting it for trial is that she's going to be in custody probably years, 2 years for trial.
It's a tragic thing, yes, but she's had more than one occasion to deter herself from committing felony offenses. And every time we test positive, it's a felony. Come on. I mean, you want to just add those up until it's overwhelming?
If she could be admitted to bond with conditions of attending inpatient rehab or something of that nature, as a condition of the public.
Court has reviewed this. It's denied. This case, we know for sure that she's not going to be testing positive. Well, it's almost certain she's not going to be testing positive while in jail. So it's set for trial. Is that what we're going to do?
Let me speak with Mr. Hager.
Terrence Limbrick. Okay. Terrence Limbrick, that's yours too.
Yes, sir.
Okay, I need Mr. Limbrick. This is another interesting case. This is a bond attitude. Is that right? Yes, sir. What are we doing tonight? He didn't show up for trial. So 2-year-old
Actually, 2 years ago, and apparently it took us so long to get him into custody.
Well, you don't know him?
I saw it on the docket. I wasn't familiar with why it was said. I thought it was an announcement saying actually. I think it off the trial 2 years ago. All of them speak with Mr. Ham.
Okay, Gary Cooper Boudreaux has been reset. That was Ryan's case. Christopher Allen. Miss Manali is On Christopher Allen, I'll talk to you.
Yes, I have an offer on him, but if I can have 3 weeks just to continue to review that with him, I need to show him more.
2 weeks good.
I would really love 3 Judge, if you could spare.
You would love to.
Would love.
You got it.
Thank you.
Christopher Allen, we set 3 weeks for a disposition hearing.
One way or the other, Judge. We will know what way.
Well, that's always inferred. Michael Best.
He is in hard county custody. He was picked up from Jefferson County Jail this past Friday, so he's not in our custody.
He's not there. Is that the best you can do for Michael? The best?
The best. Hopefully Hardin County can do something better.
It was a slam dunk. I just felt like I had to pull it off.
They softball the team,
It was a softball.
but he is in Hardin County.
I hit that one hard and just got it just out of the infield. So Michael Best, we're going to reset
For review.
in 4. Is that going to be?
Sure, Judge. I mean, he's got a pending first-degree felony over there, so.
Is this all he's got an MTRP here. Let me see his phone. Thank you.
I believe there needs
Oh, it's
to be.
PWI 3rd here. Huh?
Oh, no, it's a state jail felony.
Oh,
Burglary of a building.
Already, Judge.
I need to look at it first. Real quickly.
Okay, well, I'll have to go down.
It's a state jail felony, burglary of a building, but I think that there needs to be a new amended motion to revoke probation. I've talked to Danny about it. He's aware.
Who?
Danny,
Danny. Yes.
but I don't,
Danny Boy.
I doubt he will come back here until that is resolved. Given that.
And we'll amend the MTRP, Your Honor, once we get all the offense information from.
What are the requirements of the MTRP?
Right now, they're just administrative. He basically absconded, didn't report employment, didn't report address change, he's behind on fees. But the motion to revoke probation was filed in February of 2024. I don't think that he was picked up for custody.
Coming up on 2 years.
I don't think that he was picked up until this past September, Judge. And then
That
Hardin
can't
County.
play out well at the end of this. Okay. All right. Let's review the status in
6 weeks.
6 weeks.
Okay.
Okay, thanks. It's in Hardin County. Is where it is. I have Watisha Jackson. That was RS.
Yes,
We call that
because-
reset.
Yeah, that was reset. She's waiting on her mental evaluation still. I don't believe the offer has gotten to her.
Okay.
That's all I have.
That's fair.
Thank you.
Timothy Fund. Yeah. Anybody at all? Is in it? Timothy Fund.
Apologies.
Yes.
I'll need a fingerprint this morning.
Mr. Furnace? You have a disposition for today?
10/10, Judge.
What over what?
10/10.
Oh.
Say PM.
Well, that's 10/10. That comes out to
Comes out to what?
it comes out to a whole nine, yes. On fraction. That's class.
Probation. Second is the probation. But is he gonna give him credit for it? Or do you gotta do a 10 more days? Okay. Yeah, okay. Oh, yeah, you said,
You were Timothy Fernie? Let me see this lady right here. She's going to swear you in and give a fingerprint.
Like your selfie badge, your right thumb print. Put your left right there. One more half. And we'll see one. Right there.
I understand.
Okay. Just wait, fine.
This is incarceration, or what you're going to get is incarceration by the sound system.
Was that the one you did now?
That's it, yeah. You just.
25 CR 837 was called Timothy Justin Fernie. You're Mr. Ferns. Presently, Mr. Turk, your attorney, and the state's attorney, the defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
We may judge. Yeah.
So the way it's indicted, we've got paragraphs 1 and 2, which constitute a third-degree felony of operating a motor vehicle while intoxicated. Looks like there's 3 convictions of DWIs, and in this, in October 29th, that was 2 years ago. And then we got a prior conviction in 2018 out of Orange County for illegal possession of controlled substance. So I guess technically, all of this being found true, he was looking at up to 20 years in prison, looking at that indictment. Is that right, everybody?
That's correct, Your Honor.
Move this to it. Is that a pen?
Yes, sir.
Yes, sir. Yeah. You know how it is. We're trying to get new pads. And the zero didn't come out. Does the defendant waive a formal reading of this indictment? Can we proceed to summary? Paragraphs 1 and 2, I presume, is all we did last district. Paragraph 1 alleges that on or about October 29th, 2023 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Do you understand what you are charged with? Now, that would generally be misdemeanor, except which paragraph 2 goes on to allege that you have 2 or more prior convictions out of Harris County, Fort Benton County, and this criminal district court of Jefferson County in 2004, 2005, and 2015, respectively, for DWIs or operating motor vehicles while intoxicated. So if this were true, paragraphs 1 and 2, you were looking at a 3rd-degree felony, which carries with it no less than 2, no more than 10 years confined in prison, and a fine up to $10,000 can be assessed. Do you understand what you are charged with and the punishment range applicable, sir? An agreement's been reached where you would be pleading guilty to paragraph 1 and 2, sentenced to 10 years in prison, and then that would be suspended and you would be placed on regular probation for 10 years. Okay. Why would you help me out? What did we do in 2008?
I think you had kind of, Your Honor, last time, I believe the defendant expressed interest in wanting some help for his drug issues. And I think the court was kind of inclined to reset it and do that. He had tested positive in court and
for
it was actually a couple different things. It may have been, I don't want to say what it was, definitely drugs. I don't know if it was cocaine or ecstasy or just may have been THC and then another. There's a couple in there, and I think the court was inclined to allow him. He expressed that he had never received treatment for any of his drug issues. I think that's the problem with all of these DWIs that were drug related. And
okay, here's William.
Just
Voluntary. 1 and 2 in 2004 out of County Court at Law 2 of Fort Bend County in 2005 and in 2015 this criminal district court of Jefferson County, Texas. Do you understand what you're charged with here in paragraph 2? Yes, sir. Do you understand that paragraphs 1 and 2 constitute a 3rd-degree felony, which means you were looking at no less than 2, no more than 10 years confined in prison, and a fine up to $10,000 can be assessed. Do you understand?
2 to 10. Yes.
How do you plead to paragraphs 1 and 2, guilty or not guilty? Huh? Are you pleading guilty voluntarily and because those allegations are true? And paragraph 2, which alleges those prior convictions, are those all true and correct as they are alleged? Are you pleading true and correct to those allegations voluntarily and because they are true? You know. And are you pleading guilty and true to paragraphs 1 and 2 voluntarily and because those allegations are true, sir? Yes, sir. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Yes, sir. Understand it, discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, consultation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here? Yes, Judge. I am going to follow this agreement, if nothing further to add by the parties, and find you are, Mr. Purdy, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2. Constituting the third-degree felony of operating a motor vehicle in a public place while intoxicated with 2 or more prior convictions. And I hereby find you guilty beyond a reasonable doubt. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve and that will be suspended. You will post on regular probation for 10 years. There will be terms and conditions of probation which are normal and customary for this type of offense. And what's that? We need to fill in the instant and the old time. If you happen to hear what I was talking about, there's other recognition. No, sir. Full and complete. Once I go yeah. Now that they're not having it's an act of highly educated. You are. Right, good. Somebody told me they applied for the.
Yeah, it'll be the same.
Okay. I need Mr. Files.
Yes, sir.
Kyle Mulholland. We'll need Kyle Mulholland, please. Thank you. That does not suffice me. You want my signature or somebody else's?
It's not, so you're coming up to.
Put mine on there?
Sure.
Where? What's defendant community?
Maybe I made that an
You made a mistake.
Well, it's a big work there. My apologies.
I'd like to announce that I finally caught the probation office in a mistake. It's been 19 years and I caught them. And it was a minor mistake, but I just found a mistake. 19 years of perfection.
We're right in front.
Actually, we're going to defer that one. That's going to be deferred.
Thank you.
You go see it for the judge.
This one was one we did with all that.
Yeah.
24 CR 1375 is now called the State of Texas versus Kyle Clayton Mulholland. Is that you, sir?
Yes, sir.
Present with Mr. Turk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Good day, Judge.
I've got two paragraphs here. Do I go one or just both?
Well, this agreement here on is to the lesser included offense. So those are detailed with paragraphs 2 and 3. So
what's
stage?
One
Yes,
and
sir.
two are required for the continuous
Yes, sir.
sexual assault
Yes,
or
sir.
sexual abuse. So we're only going on one. Is that right?
We're proceeding on the lesser included offense of aggravated sexual assault of a child. Your Honor will need to,
Well, I mean, we only need paragraph in one, right?
yes, sir, and we can just take out of that
Yes.
the 30-day language of 2 or more acts. A cleaner way to do it would be to stop at where it says in the County of Jefferson, State of Texas, comma, is to stop there and then jump down to the second paragraph and have it lead to that.
Go over that one more time. Follow it.
For the lesser included offense, my suggestion would be to reading from the indictment on the 5th line where it reads indictment in the County of Jefferson, State of Texas, stop at the comma, go down to the second paragraph. And that would be the elements that are needed for the lesser included offense of aggravated sexual assault of a child. Because how it's detailed is the 2 different matters that are necessary for it to occur within the 30 days, Judge. Hopefully I didn't complicate it too much saying that.
I'm bothered with jumping from one paragraph. Okay. All right. We said do paragraph 1, lesser included. It's included. It is lesser included in paragraph 1 by intentionally knowingly causing sexual organs to contact and penetrate the sexual organ of the child.
Yes. Right.
That is aggravated sexual assault is what you're intending to prosecute him on, right?
Judge, if we're going to stick with paragraph 1, we would omit picking up with during.
But isn't paragraph 1 the lesser included from paragraph 1 that y'all move on? Isn't it within that paragraph?
Yes, sir.
Okay, let's, I don't think we need to delete anything. I don't think it just, we go new proceeding on the lesser included. It's offense, aggravated sexual assault, correct? Which is a person that.
Yes, sir.
And that's the regular probation, regular punishment of no less than 5, no more than 99. It's normal first degree felony.
Yes, sir.
Okay. In summary, sir, and we can proceed in summary and wait so far.
Yes, sir.
Reading Mr. Turk on behalf of Mr. Mohawk. Paragraph 1 alleges that on or about December 31st, 2018 in Jefferson County, Texas, you committed the first degree felony of sexual abuse of a child, continuous sexual abuse of a child under 14. Do you understand what you're charged with in this paragraph 1? The agreement has been reached by the parties that you will be prosecuted on the lesser included offense of sexual assault, of aggravated sexual assault of a child, which is a first degree felony, which carries with it no less than 5, no more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand the punishment range and the plan that has been
Yes, sir.
prepared in this case and agreed upon, that you would be pleading to this lesser included first degree felony?
Yes, sir.
I had to let Johnny have what's known. I didn't have it just now. Place a flat right there. In there, we're not going to do it. That's the much of this right there. Okay, it was SEO. It was just.
An agreement's been reached furthermore that you would be pleading guilty to this lesser included first degree felony of aggravated sexual assault of a child, and you will be sentenced to 20 years in prison. Is that your which will run concurrently with other cases? Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
I understand.
How do you plead to this lesser included first degree? Hold on. The lesser included first degree felony of aggravated sexual assault of a child as indicted in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked here. States Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? States Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment you've read it. You were guilty of the crime charged and any lesser included offenses such as this one you are pleading guilty to in this particular case of aggravated sexual assault under this indictment charging you with continuous sexual assault of a child under 14. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Thank you.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement, sir. If nothing further to add, and find you are pleading guilty voluntarily, knowingly, intelligently to this lesser included first degree felony of aggravated sexual assault of a child in this indictment. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this offense, this lesser included first-degree felony of aggravated sexual assault of a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years in prison. Also, do you understand a conviction or adjudication of such a crime such as this requires you to register in the sex offender registration program, sir?
Yes, sir.
And I'm showing you a document that has been signed. Is that your signature?
Yes.
Did you understand it? Discuss it with your attorney, Mr. Turk? Is everything true and correct?
Yes, sir.
All right. The sex offender registration admonishment dated on this date of the 24th, 22nd of October.
It's the 7th.
27th October 2025. I can't read this stuff. You guys are beginning to write like doctors. All right. It states that you understand you have a reportable conviction of aggravated sexual assault. That means that you are required to register in the sex offender registration program. You understand that you must comply with Chapter 62 of the Texas Code of Criminal Procedure, sex offender registration requirements. Failing to proper register is a criminal offense that may result in your prosecution. Do you understand?
Yes, sir.
If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to register can result in you being charged with another criminal offense. Do you understand the reporting requirements you have here, sir?
Yes, sir.
Is there anything else to add here? All right, then that is all. Thank you.
Thank you, Judge. If you want me to send yours over to the employees.
What makes you revisit?
All right, next is Gregory Woods. How about Rodney, Gregory Woods?
He's up for a plea, Judge. He's the account.
Okay. Gregory Woods, please.
Yes,
thank you. And Mr. Fine.
Yeah, fine.
Mr. Woods, that's you. Please see that lady, and she's going to swear you in and fingerprint you. Thank you very much.
Restitution.
You have your right.
Restitution of these. 1,368.
You can have one more time. Please, right there. Actually, just have another job.
Or whatever.
And we now call 25 CR 509, the state of Texas versus Gregory Patrick Woods. That is you, sir.
Yes.
Present with Mr. Perk, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
We may just.
In summary, sir, this indictment alleges that on or about August 15th, 2024 in Jefferson County, Texas, is alleged that you committed the third-degree felony of credit or debit card abuse, as it is further alleged that you committed the offense against an elderly individual 65 years of age or older. Do you understand what you are charged with here?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
So,
The agreement's been reached. You would be pleading guilty. Whatever sentence shall not exceed a cap of 5 years in prison. So You are looking at no less than 2 nor more than 5 years in prison. You could be placed on deferred or unadjudicated probation. Also, you could be placed on regular probation. Is that right? Is he eligible for me for regular? I think.
I can check. My head, I'll shoot.
I think he is.
He's eligible.
He's eligible for me, not
Yes,
maybe
sir.
a jury, but.
No, he's not eligible from a jury, but he is from you, Judge.
So you could be sentenced to no less than 2 nor more than 5 years confinement in prison. And that could be suspended. You could be placed on regular probation for up to 10 years in liens. And there would be terms and conditions of probation which are normal and customary. I see there's restitution in the amount of $1,537.68. Is
That should be $31.68, and the
That's
parties.
like a 7. Okay.
Sorry, that's my handwriting, Judge.
Is it 31 or 30?
31.
31, yeah.
This one would be 3168. Sorry, I know that.
Am I? Have you met?
Is that what you understand, that there's a loss here, sir?
Yes.
Oh. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as it's Exhibit 1 here. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents offered incorrect?
Yes, sir.
States Exhibit 1 tendered into evidence without objection?
No objection.
Admitted. Among other things, the state you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. The indictment's not read to you, you've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived, or do you want a pre-sentence report on this? I can listen to arguments from the side, from the parties, but what do y'all want?
Our intention was to ask for a PSI, Judge.
Okay, what's the state going to be asking for in this?
Well, and the benefit of the PSI is it'll confirm.
You're waiting for a pre-sentence report to make a final decision.
It's
right?
going to confirm his criminal record that we want the court to be advised about.
We will then defer further findings, order a pre-sentence report. When can we come back?
First week in December.
Is that going to be good? 5 weeks? Okay, thank you. Probation. We'll come back in 5 weeks, and then all parties can present any additional information, and then the court will make its decision. All right. Thank you. Also, this restitution. Or you, I know you're in custody, or can you or someone on your behalf help you pay this restitution back as soon as possible? That makes a big difference to this court.
Yeah, well, recently I was just, car exited, so I should be getting my social security as soon as I get out.
So you have source of income. Source of income.
Yeah, that's gonna be my social security.
So this is again, $1,531 and some change. How long do you think it would take you to get that paid back?
About a month or two, 2 months.
A month or two?
Yeah. Without making your life harsh, like we will leave it.
For 2 months.
Okay.
You sure?
Yes, sir.
Okay. For a moment, 1 day. All right. That, if the court puts you on probation, I'm going to give you maybe, 3 months just to be on the safe side, but that would be important. And if you fail, your probation could be revoked and you could be sentenced up to the full range if I place you on probation. Okay. Because that's why I want these people, the victims, paid back as soon as possible. Anything else? Okay, we'll see you back in 5 weeks. Rodney Petty, that was. Mr. Fine? Yeah. Rodney Petty, please, thank you.
Yeah, speak up, at least that is.
Oh, I remember this. That's
Yeah. Yeah, I have several dismissals on Donna Arnold.
There's two on there. There's going to be a plea on one, Judge.
Thank you very much.
So I sent you two dismissals that are conditioned upon the plea, Judge.
You do this, see. Okay.
Sound fun? Which one? I feel like every day.
Okay, see her? Thank you.
Richard, can you please swear or affirm to tell the truth and nothing but the truth, so be God? Thank you for the right thumb print.
Picture.
Place it flat right there.
Make sure.
Flat, don't roll it.
That's the one we just did.
Flat, don't roll it.
Yeah. Yes.
Famous words. Flat, don't roll it.
Say it a million times a day. Good. Can you go say it another day?
Right here, sir. Thank you. You are Rodney Eugene Petty. Yes, sir. Correct. We call 25 CR 1224, the state of Texas versus Mr. Petty, who is present with Mr. West, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges on or about August 11th, 2025 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. Do you understand what you were charged with here, sir?
Yes, go. This is case.
Gotcha.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
What's the update on new pads?
They've been ordered.
It works.
I understand, Judge. I do know the new pads have been ordered,
Frustrating
but
because
the
of this-
current shipping status, I'm not privy to that information.
just half of what I'm writing is showing up, and I have to rewrite it over.
It took about 45 years to get that going earlier. So that's problem we're getting the teacher.
That's about what Ralph Kindler tells us to get going on this. About the same. An agreement has been reached, sir. You would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, and fined $500. Is that your understanding? Yes, sir. If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
I'm guilty.
Are you pleading guilty voluntarily? That is on your own free will.
Yes.
And because you are guilty.
Yes, sir.
Let me show you it's marked. Well, States Exhibit 1, did you sign that document voluntarily? Understand it. Discuss it with your attorney. The contents all true and correct.
Yes, sir.
States Exhibit 1 tended into.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. Freely and voluntarily, now you know what you've been charged with. That's read here, you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Deferred.
Yes, it's okay. And the plan is you're going to be pleading guilty based on deferred or unadjudicated probation for 10 years. You do well, I'll shorten it to 1/3 of it. Fine $500. Is there any restitution here?
Not that I know of.
No, sir.
Is that your understanding of the plan?
Yes, sir.
All right. Anything else to add?
Nothing much, Your Honor.
If nothing further, I'm going to follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, including you must pay a fine of $500. And then there will be an anger management program that we are going to ask you to or order you to take and complete. That's a good thing. It always helps you try to think ahead a little bit about what the next action you take and how that might adversely affect the rest of your life.
Can I add something?
Go ahead. I don't never know what's about to happen, but
I'm only going to the Dream Center and the Dream Center.
Nobody stops you from doing that.
I'll be able to do that with being on probation and still do my classes.
If they allow you to, yeah, but that's going to be your choice. I'm going to be giving you other terms and conditions of probation, but whatever you feel like can help you be the best person you can be, do it.
Yeah, that'll work. That's pretty.
You got to be careful on this. If the probation can be revoked, and I can then find you guilty, and then you can be sentenced up to 20 years in prison. And this includes a deadly weapon, a metal rod, as the item used in the aggravated assault as a deadly weapon. So if you were sentenced to 20 years, you'd have to serve 10 before you're parolable. So there's a lot riding on you doing the right thing. Yes. And here's what's ironic here. This isn't like punishment. These are most of these requirements are what we all have to do properly to conduct ourselves every day. Like commit no offense, don't associate with disreputable people, support your dependents. I mean, dress appropriately, conduct yourself properly. I mean, for everybody should follow these. So there are some that are in particular. Well, much of this is getting you back on the track. Sure. All right, you understand what has happened today here, Mr. Tepe? Please see the probation office. Milton Richard. Milton Richard.
It's 2 cases, Judge.
2 cases.
Good.
Marcus, what are you doing?
It's after me.
Is that for you?
It's not been a quarter, so he's always after me. He's always the last one. I'm always the last one unless Marcus is in here.
My maiden name was started with another.
Sure, please see that lady. She's going to swear you in and get a fingerprint. Thank you.
No. Right here. No, it's gonna be better than that. It's okay. I got the whole thumb. Can you get it one more time?
Nothing but the thumb. So
Okay. No, it's okay. You're gonna see it go over there.
Right here. Sign that too.
And 2 cases are now on. Cause numbers 25 CR 1248 and 1249. Each are styled the state of Texas versus Milton. Is it DeAndre?
Yes, ma'am. I mean, yes, sir. I'm sorry.
And you're charged in each of, in 1248 with the state jail felony, theft of property.
Yes.
And in 25 CR 1249 with the 2nd-degree felony of robbery. Do you understand what you're charged with? And again, the theft alleges on or about July 24th, 2025 in Jefferson County, Texas, committing theft. It looks like cleaning supplies. And
No, I probably about the same things approved. How many judges?
and that would have been that wouldn't have been a felony offense except for paragraph 2 of clause number 1248 alleges you have 2 or more prior convictions of thefts. So thus, if that's true, anytime you steal a pack of gum, it's a felony from now on. So you got to be careful about being honest. This says you've been convicted in 2023 out of County Court of Law 2 here of Jefferson County of theft, June 20th, 2024. That's a special date for me. I'm not going to tell you why. County Court of Law 2 of Jefferson County, Texas. And then February 24th, 2025 in this court, earlier this year, you were convicted. And then after that, darn it, I'm kind of disappointed to see you back. But in July here, you get caught for this new theft. So you got to be careful. A theft of a pack of gum from now on, that low of an amount is a felony. So be honest. Do you understand?
Yes.
You got to follow.
Be accusing me of stuff without having too much money.
20, next is 25 CR 1249. This alleges on or about August 17th, 2025, you committed the second degree felony of robbery. So in this state jail felony in 1248, you are looking at no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. You understand the punishment range there. And an agreement's been reached that you would be pleading guilty, placed on deferred or unadjudicated probation for 2 years. And this would run concurrently with this next robbery case here. You're ordered to pay restitution in the amount $258.57. Do you understand? Is that's what they say was taken?
When I gotta pay that?
And you gotta pay it as a portion of probation as soon as you're able to, okay? You're gonna get a job or something? And
I be having a lot of money, that's why they did that.
Sir?
I be having a lot of money, that's why they did that.
That makes one of us.
I didn't take nothing out the store.
Nonetheless.
I didn't take nothing out the store, I didn't even have a
Well,
choice.
that's.
I think I'll be having too much money.
I'm sorry. Hold on. It's not in the tape. Hold on. Sex. Hold on.
Okay, so.
This says you were at HEB.
Yeah.
Collected items. Are you gonna stop talking over me?
Yeah.
Thank you. It says you collected a bunch of objects, put them in the shopping cart, then left out into the parking lot and didn't pay. And that's where they got you. You remember that?
Yeah, I know.
Okay, well, you can't leave the doors with the stuff.
Much money on me. I went to the self checkout and thought
Well, you got to pay this back.
I paid.
$258.57. This will be for 2 years on probation on that one. In 25 CR 149.
Like I'm doing it, I'm just all over the bank. Like I'm doing it, I just all over.
Hold on. Don't be volunteering information. She's taking everything down. You don't want to say something that might get you in trouble. Okay, let's see. So, on this indictment, again, how do you plead to paragraphs 1 and 2? Guilty or not guilty?
I am guilty.
Are you pleading guilty voluntarily and because you are guilty? Yes?
Yes, sir.
All right. And the prior convictions that we talked about, are all of those true and correct as they are alleged in paragraph 2 of the indictment?
Yes.
And are you pleading true and correct to that voluntarily because it is true?
Yes, sir.
All right. Let's go to 1249. In summary, this alleges that on or about August 17th, 2025 in Jefferson County, Texas, you committed the second degree felony of robbery by grabbing the victim by the arm and shoving her. And this was while committing theft. Do you understand what you're charged with here? Yes or no? Now, this is a more serious crime. This is a second degree felony, which means you, if convicted, you face a term of not more than 20 years in prison or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are facing? It's serious. That's all robberies.
Yes.
An agreement's been reached where you would be pleading guilty and not found guilty. I would place you on deferred or unadjudicated probation, which can be up to 10 years in length. If you follow those terms and conditions of probation, then we can end it before 10 years are up by good behavior, and then the case would be dismissed. You would not be found guilty. Do you understand how deferred or unadjudicated probation works?
Yes, sir.
If I follow this agreement, you have no right of appeal in this case. Do you understand? How do you plead on this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty in each case?
I am.
I show you what's marked as State's Exhibit 1 for each of these cases. Did you sign those documents
Yes, sir.
voluntarily? Understand them, discuss them with your attorney? Is everything true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each case?
No objection.
Without objection admitted. In this case, this states you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses in each case. Totally satisfied with the representation provided by your lawyer. All of this true so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence reports are waived in this.
Please, yes.
Fine. I am going to follow these agreements, sir. And finally, I'll just, yeah. You, in each of these cases, you are pleading guilty voluntarily, mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each case to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer any finding of guilt in each case and place you on deferred or unadjudicated probation. And you will be on probation for 2 years in 25 CR 124A and for 10 years in 25 CR 1249, the more serious robbery.
Why that 12 years probation?
No, it's 10. They're going to run together.
That's the whole 10 years.
Yes, sir. You must pay restitution in the amount of $258.57 in the theft of property case. And you need to pay that as soon as possible, but can you pay this back within 3 or 4 months? $258.57.
Yeah, I can pay back in 4 months. I can pay back in 5 months.
Okay, I'm going to give you 4 months.
Okay.
To do that. And then you must complete a theft prevention class, which is a good thing. And then in the robbery case, I'm going to place you on deferred or unadjudicated probation for 10 years. Again, these 2 cases run concurrently. There will be, is there any restitution in this robbery?
There was none claimed.
Okay. Then there will be terms and conditions of probation. And then there's something called moral reclamation therapy. And this is just a good program. It teaches you to live honestly, harm no one, give each person respect. The things that everybody can help being reminded of that are important. And it's a good program. Make sure you follow these. If you fail, then I'm not finding you guilty on these cases. Do well. And you, at the end, each of these cases will be dismissed. If you fail, your probation could be revoked. You could then be found guilty and sentenced to 2 years on this state jail felony theft and up to 20 years on this robbery. So we don't want that. Please see the probation officer and do well on probation, sir.
But it's like, I don't really when you take something out there, I ain't no money.
Anytime you commit a theft and you use aggressiveness, it becomes a robbery.
Yes,
Thank you. Brandon Charles. Marcus, you got it? Help me on this.
Judge, this is I believe it's second or third request for bond reduction. It's murder charge.
Is that what this is?
Yes, sir.
Brandon Charles?
He's next door, Your Honor.
Okay. All right. If you can get him while we're doing that. Just Jeremy Ojimon.
What? My ours are good. It's.
Has anybody seen Odwin lately?
He was here earlier.
No, he's here. I think. And then we've got Leo Cover, right?
Like, would be getting something.
We're ready?
I'm signing him up.
Are we ready? I'm doing this. Ready, everybody?
Mr. Webb, I go to the
It's always an adventure. We don't know what's gonna happen. What are you doing?
Wait, between Donald Arnold.
Are you ready on it?
Yeah. Yes, sir.
Okay.
It's a one of the great
Let's try Donna Arnold. Yeah.
We give it Charles.
I have Charles. We'll be the female.
Thank you. Let me get Donna Arnold and then Charles.
I'll let you borrow one. Hang on. Think this is it. I'll let you borrow it. I'll make sure there's no. NCS and stuff, you know. No. It's great. That was the release fee, so the one that's got 90.
Hi.
Hi.
Please see this lady. She's already did. Oh, okay. Donna Arnold, 3 cases. What are we gonna do here?
She's taking 10 over 10 to say P on the TDC case.
Which one is that?
That's 1879.
Okay.
And the two state jail.
What? 15?
79, 1879.
1879. And then the two others, 760-1880 are dismissed?
Was the fish, yes, sir, the fish state.
That was gonna be. Right. Okay.
Correct.
24 CR 1879 was the call. The state of Texas versus Donna Donnell Arnold. That's you,
Yes, sir.
present with your attorney and the state's attorney. Mr. Kimler, does the defendant waive a formal reading of the indictment and arraignment or here can the proceedings summary?
She does, Mayor.
And suddenly this indictment handed out on September 11th of last year, over a year ago. It states that on or about July 6th, 2024, in Jefferson County, Texas, you committed the 3rd-degree felony of fraudulent possession or use of credit or debit cards, which are, looks like
Back to
less than or equal to 5, more than, equal or more than 5, but less than 10 items. And that's a 3rd-degree felony. Do you understand what you're part of it?
Yes.
I'll wait till see what he does on the smart page on the side what he was doing.
3rd-degree felony means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, fine may be assessed not to exceed $1,000. Do you understand?
I put a fine. I don't think of it.
An agreement's been reached where you'll be pleading guilty, found guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation.
Log into this one and try to open my.
For 10 years, fine $500. Is there any restitution here?
The state didn't indicate that the collision on, I'll defer to Mr. Henry. No, I'm aware of, Judge.
Is that what you understand, ma'am? They got everything back. They didn't lose anything. Is that right?
Right. Yes.
Okay. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will
Yes, sir.
and because you are guilty. I'll show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection?
No objection.
Put an eye out there, sir. State's Exhibit 1 tendered into evidence without objection, admitted. Correct?
Correct, yes, no objection.
This states, among other things, you are mentally confident to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, the indictment's been read to you, you've read it. You were guilty of the crime charged in any lesser included offense. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Which sentence report is waived?
So we're.
You know, while the experts are here, like, you see what's going on here. We're trying to write and it's just not taking. See, like this right here is Rife's signature, and that's an example. We try to write and it just
There's no way
the wording.
That's an issue with Active Ink itself, which is being replaced. The program's being rewritten, the actual the whole thing.
You know, something good's happening right around the corner, right?
Yes, sir.
Good.
Do you need a program for this?
Not that I've heard. Also,
This technology,
he's the expert.
Technology, this whole technology thing, I think we're going down the wrong road. Just saying.
It'll get better.
Like I'm gonna let you have to be in charge of nuclear weapons. I don't think so.
And nephew's actually is working the same.
Wait a second. So what the family does. You're not giving him any hints on how to deal with the nuclear weapons, are you? Of all things. God bless you. Oh, I'm going to file disagree. Okay. I'm going to find you are pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of the taking guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third degree felony of fraudulent possession or use of credit or debit cards of equal or over 5 items for less than 10 items. Could have been worse. But still, you're looking at up to 10 years imprisonment. I sentence you to 10 years confinement in prison. I'm going to suspend that and place you on regular probation for 10 years. You must pay a fine of $500. There will be terms and conditions of probation, which are normal and customary. Again, you're telling me no restitution here. If we find out there is, that will be, we'll have to have a hearing and that will be ordered. I always paid, you have to, that's how you fix when you take value from others in thefts by paying them back. There will be terms and conditions for probation, normal and customary for this type of offense.
Successfully and successfully can be accepted.
I know that we're getting to that and that's going to be, you're going to be confined here a little while because we want you to attend and successfully complete substance abuse felony punishment, which is a great program. And it really has people with substance abuse issues. The recovery rate is like 80, 90%, isn't it? It's fabulous.
She's familiar with it. She's already done it once. This is her second trip.
What happened on that? Why didn't that take the first time?
Why didn't it work?
I'm not really sure. I got back.
You would know.
I got out and started hanging with the same people, the same crowd. You know, it was all my fault, but yes, sir, they did.
That was 2012, and since it's been such a lengthy period.
Not to me and my age.
Well, I want her to go again, Judge.
She missed your hands doing that as well, Your Honor, with her criminal history. I think hopefully this time she'll benefit from it and maybe it'll stick.
It's important who you run around with. You're not going to be any better than the worst person you run around with. That's why it's always good to run around with people even better than you. They pulled you up, but the worst will drag you down when you hang around. That's just long custody. That's the life of those. Until you can understand and appreciate that.
What do you know?
And he ends that song with the right lyrics.
Well, it's true.
That's true. It is. It's true. That's the way it is. Okay. Do you understand what has happened here? Yes. Don't fail. You're looking at 10 years in prison. If you do better.
Thank you.
You can do it. Okay. Now, on Donna's, we've got 2 other cases. Those are to be dismissed. Is there any
two, Judge?
Your Honor, Mr. Lewis, do you want him to proceed to he's off the trial with Merrick Lewis?
Hold on, let me deal with this one time when I was talking. Okay, for the record, 24 CR 1880, Donna Arman dismissed as part of the plea agreement. Next.
It's all down, so look quick.
I may be able to move off the trial document.
Okay. We're engineer. Thank you.
And next 25 CR 760, That is dismissed as part of this agreement on Don's knowledge. Okay, who do we have next month?
Charles. Brandon Charles.
All right, come on.
Yeah.
That's it? Just on today started?
Yeah.
What are we doing? Is it disposition?
No, Your Honor.
I'm looking at this napkin thing. Okay. Okay. 23 CR 1121, Brandon Dion Charles Jr. That's you?
Yes, sir.
You were charged here with an indictment of first degree murder handed up by the grand jury on or about August 9th, 2023.
Yes, sir.
And okay, what's today?
Your Honor, this is
This is set for trial again.
I don't know.
What was it last set for trial?
It's been a while. Well, it keeps getting pushed on off docket.
Why?
I guess because of how full the document for murder is.
Well,
I'm not certain.
Okay, I didn't know if there's something special on this. Is everybody ready on this? And
Trial, yes, sir. This is a third bond reduction request.
It's already been reduced twice, too.
does he have any prior convictions?
No, sir.
This is assault on a public servant, third degree felony. That was assault causing class A misdemeanor, juvenile. Then I've got a murder. I guess that one's this one dealing with here. So no prior convictions, is that right?
That's what I understand, Judge.
Okay. This, again, the probable cause affidavit alleges that the victim, Jemiah Dixon, was found laying on the parking lot, shot in the back. Witnesses stated that the defendant shot and killed the victim. And the defendant was interviewed to deny any involvement. And that's the nature of this. Court corrected the indictment on two places, deleting some words and correcting the spelling of another in the indictment. And right now, the defendant's bond is set at $350,000. Go ahead.
All right, Judge, as noted, this is our.
When is this set next for trial, by the way? I'm sorry.
Last week, Judge, so we haven't set it for a new trial date yet, but it will likely be after the first of the year.
Again, this is I believe our third bond reduction request. The defendant has been incarcerated pre-trial now for 2 years and 5 months, Judge. The person identifying the defendant as the shooter, number one, there was an issue, a confrontation between the defendant and the 14-year-old earlier that day. But that 14-year-old has since passed away due to a gunshot wound. In tandem with the court, I don't want to mislead in any way.
The witness passed away or somebody else?
The witness.
Eyewitness.
The only eyewitness to the event?
Mm-hmm. But
they're passed.
But then we have a jailhouse confession, and also I think there's been a DNA off of shell casing, I believe.
Do you have that information?
The DNA, yes, sir. The jailhouse confession, what did arise, it's an issue where, number one, the defendant never would have had time to leave the location the apartment complex where this occurred. And number two, the jailhouse snitch identified the wrong caliber of weapon. But in any event, as Mr. Laird represented, it is true that there is a DNA match or alleged DNA match with regard to one of the shell casings. And so that is where we are at present. And like I said, it keeps getting reset. It's currently at 350,000. We'd ask for another reduction, Your Honor, just to try and let this defendant secure a bond prior to trial.
What's his stay?
Judge, murder cases, we've had higher bonds than this, and I think part of the reason the bond was reduced before may have been because of the circumstances, but now that we've got the DNA tests, I think everything's shored up to where we're sure that we've got the right person.
I know.
For the safety of the public, we'd ask the bond to stay at 350,000.
When is it set for trial?
Not yet. It was set last week, Judge, but didn't get those.
Okay. When's our next docket set for the first year? Please.
The first trial docket of the year is going to be January 5th.
Okay. Put him up first. Got all your ID ready for that?
Yes, sir. Yes, sir.
We could be ready.
It is far too long. The way this court moves is correct.
And then as a side issue, my client had requested an opportunity to take a polygraph examination.
That's
not
mine, but
yes, the prior ADA agreed, but she's left. So I need to approach Mr. Laird about that.
Do it.
There should be nothing that interferes with that trial.
All right. We'll set that for trial and we'll set that first priority. Okay. Thank you. I will continue to consider the bar. I'm glad to. Right, did you have something else?
Mr. Lewis is on the service. I think his father had died. Mr. Lewis on the trial docket. Have that briefly recall.
What is it?
Your Honor, you numbered it number 3, and Mr. Kimler wasn't here. I advised him that you were going to send that over to drug court.
Yeah. His particular approach, Your Honor, what his situation is.
Nobody.
What's the deal?
His father.
Well, nobody said that?
Well, he wasn't present, Judge.
I was late. Good morning.
We need to be.
I was trying.
Okay. Okay.
I have no objections to a continuance under these circumstances, Judge.
What's the situation?
My father died. It's my grandfather.
Your grandfather passed.
I was wondering if you could.
When did he die? No, sir.
That was Friday at 6:00 p.m.
What's the funeral plans?
We don't have, it's just, we don't even have a death certificate.
He's talking about Friday, this past week.
This 2 or 3 days ago.
Although the state wants to prosecute this, and this has been said many times, I know Mr. Lewis has shown up at every deal.
I know.
This is a personal, I have no objections at all to continuance.
It aggravates me that we're having to do 3 years waiting time for these cases, but I can only try one at a time.
I've had my witnesses lined up. I can do it again, Judge.
We could have a short turnaround. Ready. I mean, I'm ready to go. This is in deference to Mr. Lewis.
There's some bond only dockets that are coming up that this wouldn't, if it was placed on there, will rise up to the top just because of its age.
We got other cases that can, there's no end to this with the 16th highest crime rate in the state. There's no end to cases I'm going to try. So
yes,
I can substitute this one for another one. When do we want to reset?
I'll defer Mr. Daniel.
There's some bond only dockets that this, under the clerk will place it on there.
This year?
Yeah.
We have one coming up in December, I believe.
Do we have one in December?
Yes,
we can place it. Okay, it'll be reset in December. Please get it reset.
Thanks. If you want to, yeah, good luck, Mr. Lewis. Your Honor, if you want to revisit the trial docket as to another one of my cases you want to send, I'll be glad to go.
It's brand new trial. Okay, I've got. What are we doing on Leo cover?
I think they're working on paperwork, Judge.
The plea on that?
Actually.
And then Jeremy Ajameni is still left. And that's with Auburn Samuel, correct?
It's supposed to be a plea, Judge, and
Is he coming back?
I don't know, Your Honor.
Okay.
I actually said that too.
What else do we have left on this?
Judge, I know that Mr. LeBlanc was,
Let me look at this trial
yeah,
document.
Mr. LeBlanc was working with the family on Dodd. That's a possible disposition.
Just waiting on them to get through talking, see what they're doing.
I haven't heard from Langston on
Okay, I have,
Clever.
I've got.
Derek Lewis is 3. Then let's just move up. Xavier's, well, everybody's in jail. Except Derek.
Court and handle jail.
But we can go to drug court and they'll handle the
Yes, they.
in custody.
Yes, so they can.
So
inmate.
Xavier Senegal will move up.
That's mine.
That's my.
That's my, okay, stand by then. How about Jerome Marks?
It's a good one for there. Judge,
Okay.
because of the link.
That's Mr. Wilkerson's case, Jerome Marks. Let's move that one over to the drug court.
Yes, sir.
Thank you. We need to call Mr. Wilkerson and we'll let him.
I know that the campaign's good, but enough.
Okay, on the plan with Leo, he's pleading to one and others are going to be dismissed, I believe, correct?
Yes, sir.
On Leo.
Judge said, Bridge, you're looking at time for something.
Oh, hold on. Let me give
Going on that, some
Hold on. Mute here for just a second. So stand by things.
Great. I know.
Do we need him out now?
He's almost finished. They're still signing it, but I've already got the dismissal signed on the second case.
He's still representing himself, correct?
Yeah, Your Honor, John's helping him know what the paperwork
Who
is. John West, you had him at standby counsel. He's helping him with the tablet.
He could be like, hey, I book your room. Kind of like all the.
See what my witness says, Judge, on my murder case. My witness, I found in the Oklahoma County Jail, waiting extradition to Missouri for some robbery cases. I got him. They're going to get him today.
Since everyone else might be sides, ask them, say they're there in the fifth. I'm granting the testimony of the reader, then keep it all graded. I see himself. Speak those ways, always on the very different. So, maybe that should. It's sad. Yeah.
Here's the, Leo's.
Thank you. For Leo. Leo, here's all your stuff. How are you? Is the paperwork done, ready to go?
See the square minute.
Oh, you need to go over there. She's going to swear you in and take your fingerprint. Thank you.
Raise your right hand. You can wear marker. Fill the number that we talked about. He's done.
Just one.
Wait, don't roll it.
Why did I think it was 3 cases? There's only just a 2.
Okay. Flat right here, right.
Okay, do it one more time. Just make sure we get a good one right here. Okay, you go stand in front of the judge. Teacher. Here. So.
Yeah, must be the numbers, dismissal.
I'm sending you the paperwork now. That's-
There we go.
I haven't got to you in the report yet, but. I did 12%. I haven't heard back from them, but I know that it's been over the receptive.
That's Friday and it should be done about child.
This is not the same word, because I got, I'm just trying to know what. We're not just like. Some liberals off in business. So. Get this signed in second chair view, right? Okay. Last time when we do it. Sort of get the. Well, I get this line, you know, charge. He said, appreciate it. But okay. I will see if I can find them. What's wrong? Sir. Yes.
Getting all this, trying to get this equipment to work.
I'm still waiting to see if he's gonna take off. I don't think he will, but. They feel me about the time. That's in case I'm okay.
Only 2252, right?
2232, Your Honor.
32.
Yes, sir. That'll be the
2231.
yes, sir. That was the dismissal.
32. All right, we now call 23 CR 2232 and cause number 23 CR 2231, the state of Texas versus Leo Cover, who is present and representing himself, self-represented pro se, and the state's attorney. And in this case, the defendant is going to be pleading to cause number 2232. And as part of the agreement reached between the defendant and the state of Texas, 2231 is to be dismissed today. Does the defendant waive a formal reading of this indictment in 2232? Can we proceed in summary, sir?
Yes, sir.
And again, let's deal with this representation pro se that Mr. Cover has handled in this case and insisted that he represents himself. And we've been over this a couple of times, Mr. Cover, but just for the record, just to make sure we are all covered, do you understand that in these legal matters, if you are unable to hire a lawyer can be appointed to represent you at no charge. You can also represent yourself, even if you do have money to hire an attorney. And you have insisted consistently on representing yourself in these cases. And we've talked about this several times, that representing yourself, unless you are a trained legal expert, you tend to have a disadvantage if you don't know the rules of evidence. God bless you. The penal code, the Texas Code of Criminal Procedure. And then you and I have discussed more than once your insistence that you are familiar with those subject matters. You have spent a lot of time poring over them, and you feel that representing yourself was in your best interests, and you were making that decision voluntarily, knowingly, intelligently, and after discussions with this court. Is all of that true and correct?
Absolutely, yes, sir.
And you even filed a petition to proceed pro se back in February of this year, which was a 12-page document. And in that motion, you stated, among other things, that you are indigent. You are asking this court to proceed as a pro se litigant, requesting that me, the judge, and this says in the 252nd, but that's okay. The criminal district court, we both have the same jurisdiction, and wherever you are referring to the 252nd Judicial District Court, I will order that the record reflect you intend this criminal district court where I am presiding, and that your insistence, you are stating that you understand and appreciate the pros and cons about representing yourself. You've thought about this long and hard, and it is your consistent insistence, and as of today, to proceed pro se, representing yourself and waiving your rights to an attorney that the court has provided to you on a standby counsel with John West. You've always had an attorney here to help you. You had Mr. Grove before, and now Mr. West, who's present here. At any time during these proceedings, if you need to consult with him with any advice, feel free to do that. Tell me, and you will be allowed to.
So we just talked.
The court has dealt with you on several times and feels that you are intelligent and confident and astute with much of the law, and probably could have done well going to law school and becoming a lawyer if that's what you had decided you wanted to do. But I am going to allow you to proceed pro se in this proceeding. And it's my understanding you are going to be entering a plea of guilty to 2232, this state jail felony of theft, correct?
Yes, sir.
And it's going to be the lesser included Class A, Your Honor.
All right. Is that true?
Yes,
That's what
sir.
the plan is.
Oh.
We got to make sure that this is what is clear here. Because that wasn't filled out here. So there's a part on the agreed punishment, prosecution for lesser included offenses. We need to, I'm checking that. And Class A misdemeanor theft. Is all that true?
Yes, sir.
Okay, everybody initial that, please, on the left side, up at where you're at the top, is that portion proceeding on the lesser included, just initial it.
Yeah.
Okay, does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, Mr. Cover, this indictment alleges that on or about July 30th, 2023, in Jefferson County, Texas, you committed the state jail felony of theft of property. Do you understand what is charged in this indictment?
Yes, sir.
An agreement has been reached that you would be pleading to the lesser included Class A misdemeanor of theft under this indictment. Is that your understanding of the plan?
Yes, sir.
A Class A misdemeanor of theft means it carries with it up to 1 year in the county jail and or a fine up to $4,000 can be assessed. Do you understand the punishment range?
Yes, sir.
I'm writing on the face of the indictment this is what is proper and normal. It's showing state jail felony. I am writing defendant will plead guilty to lesser included Class A misdemeanor of theft under this indictment. So if somebody ever pulls this, they can see it wasn't a felony. It was a misdemeanor.
Here, 60, but they'll, they're living with 50, but I'm off and doing that. Pays them. Okay, so it'll be a 10%. I said, what trial? But you know, I'm putting right now for the moment. That's fine. Oh, no, I don't think so. That's a big one.
No, he is. That's welcome. I don't know.
It's one of our cases. I don't I'm like, we're not liking. I'm not supposed to come so.
Right, you don't know what I got.
All right.
Greg, it only gets all the way from my county for Mr. Ellis. It's in jail. I'm trying to spell the murder case today, so I got my witness lined up. Against Brian Matuska. No, we got the 911 caller sitting there watching part of it. Got Tierra that was she's in jail. I got her coming over. She's just got Demonte, who's in Old County. He's coming. I got him unfortunately to testify, and I got the only one I'm having trouble finding is Joaquin, but I don't really need him because he gave such an excited utterance. It's going to come out. But since the president going to come out on the videos, like I'll just statement will come out. So I've got everybody, police officers. It'll be a long trial. Just a matter of getting them all to say things, but they need to say it's truth. Ever heard of these paintings? Or green? Never. Even can. I don't know.
Okay.
And look cut.
I'm going to ask everybody to initial at the top and the bottom, this lesser included punishment. So it's on the state jail felony as it was indicted, but we want to make it clear everyone is agreeing we are proceeding under the lesser included Class A misdemeanor of theft. Just initial it. There you go.
Oh, there you go, here. Sure. Okay.
Again, the agreement is the defendant would be pleading guilty, sentenced to 1 year in the county jail. And is that going to be suspended and he's placed on 2 years on regular probation? Is that what we're doing?
That's correct, Your Honor.
Okay. He's not just given credit for the time he has spent?
It's just there's restitution in this case, so that's what we did the 2 years. And I did advise that the court cares very much if that restitution is paid back, that the court rewards that.
Yeah, I remember we were talking, you had stated once you got out, you ought to be able to pay this pretty quickly.
Absolutely.
How long do you think it would take?
Probably within 6 to 8 months.
Okay. If I follow this agreement of 1 year county jail suspended for probation of 2 years and restitution in the amount of $8,100, is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you shall have no right of appeal of your case. Do you understand, Mr.
Yes, sir.
So, big question. How do you plead to this lesser included Class A misdemeanor under this indictment of this theft? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
All right. I show you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Is everything true and correct?
Correct.
State's Exhibit 1 tendered into evidence without objection, admitted. Yes, sir. Thank you. Among other things, this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, such as this Class A misdemeanor of theft. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And once again, you totally understand and appreciate and acknowledge that your insistence of pro se or self-representation in this case is being done voluntarily, knowingly, intelligently, and because that's what you insist on doing.
Yes, sir.
All right. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes.
All right. I'm going to follow this agreement and find, Mr. Weber, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of theft. I'm following this agreement. You are hereby sentenced to confinement in the county jail for 1 year. That is suspended. You are placed on regular probation. For 2 years. That's what we're about here. For 2 years, and you are ordered to pay restitution in the amount of $8,100. There will be other terms and conditions of probation, which are normal and customary for this type of offense, which includes a theft prevention class that all people charged with crimes of theft must follow. Look, you do well. I will shorten this to 1/3 of it.
Sir.
So you can do the math there. 24 months, 1/3 is 8 months. One other thing I want to include, there was a petition to proceed pro se that you sent and was filed, and this was sent on or about February. It was dated February 7th of this year, filed on or about February 17th of 2025. I'm going to make this part of the record and it is your petition to proceed as pro se, and also the court will grant this. I have a page here that you've given me to grant it. It looks like this. Oh. Place. There's not an order, but what I'm going to do on this prayer, I'm going to sign this order. I'm going to make this order on And so this court will make this part of the record from this 12 pages of a petition to proceed as pro se, that the court on this day orders that and finds for the record that the defendant Leo Cover voluntarily, knowing and competently is voluntarily, knowingly, and competently capable of pro se representation in this case. I've signed this and on this date and made it a part of the record. Do you understand what has happened today, sir?
Yes, sir. I do.
Anything else to add?
And Your Honor, just we signed a motion to dismiss on 2231. That's the other case.
Case is dismissed. That case is dismissed. Do you understand what has happened today, Leo?
Yes, sir. I do.
Good luck to you.
Thank you.
Take
Y'all
care.
have a good day.
Yes, sir.
Good luck. Appreciate you.
All right, here's this. John, also thank you for your help on this case as well. And I'm gonna, this petition, we'll make this court's exhibit 1 on this day, okay? I'm saying. Here's this. Okay, what else? What else?
Judge, I have a case on the trial that we need to bring me, get him brought out here. I just want to run the offer by and show it was rejected, the latest.
Who is it?
Coy Dodd.
Coy Dodd, please. Thank you.
I'm not, last week when I was up here.
Come on up, sir. Come forward, please, right here. And we call cause number 24CR115. Call over here. Thank you. Coy Wayne Dodd Jr. That's you, Mr. Dodd? Yes, sir. Okay. You were here with Mr. LeBlanc, your attorney, and the state's attorney. We are set today for the trial, and you have been placed on the trial docket today, and we have you slotted to get this trial done. So, Mr. LeBlanc, did you want to put anything on the record? And by the way, do you understand fully you were indicted in this case back in May of 2024? Yes, sir. For the first degree felony of murder, which means if convicted, you face no less than 5 nor more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand, sir?
Yes, sir.
Probation is not an eligible option under the law for someone convicted of this crime. Do you understand?
Yes, sir.
Yes, go ahead. Mr. Oda, on behalf of the defendant, you wanted to?
Yes, Your Honor. We've been, there's an offer, and I passed it on to my client. We don't want to make sure that he understands everything that today you were given an offer, you understand that?
Yes, sir.
And that offer was what, 50 years, and you're rejecting that offer? Rejected and go to trial.
No, we're drugs.
Are you making that decision voluntarily,
Yes, sir.
knowingly, intelligently, and based upon discussions with your attorney?
Yes, I'm ready to go to trial whenever y'all ready.
Sir?
I'm ready to go to trial whenever y'all ready.
Okay. Anything else?
Okay.
Anything else? No. All right, so we're gonna get this thing to trial. Thank you. That is all. Anything else? We recess. Get trial back in. One.
E646491. Did you take this young lady's file to Mr. Dubois? Missed 195 is your total. You're all set.
Thank you.
Have a good day. Amanda Dawn Igna, 25B149457. Your name, ma'am?
Yeah.
All right, so you're going to plead to impeding. It says two vehicle crash, no injuries, minor damages. So I'll take that and to that charge of impeding traffic, responsible or not responsible. All right, I'll accept the plea. Dismiss the original charge, 195. You're all set. Sorry to keep you waiting. I had to check on you, okay?
Thank you.
David Scott Morton Jr. Is David Scott Morton Jr. here? Rachel Marie Giles, 25B149683. All right, your name?
Rachel Giles.
All right, so you're going to plead to impeding traffic, right? Responsible or not responsible?
Responsible.
They got you going 50 and a 30 in a school zone. Please slow down, okay? All right, 155 is your total. You got a good record, though. You're all set. Original charge is dismissed, 155. Thank you.
All right. Good afternoon, everybody. This is Judge Middleton. I'm here at the court. We're about to start our landlord-tenant docket. Mr. and Mrs. Wiedemann, you're sideways on your phone. I'm going to fall over there. That's better. Thank you. Legal aid is here with McBauer and Jordan Harden is here. So our first cases is Wiedemann. Then we have Fusen and Grant. They're not here. Melissa Grant is here for the Richmonds. And Schutzel, we have one defendant that isn't here. Maybe we'll go over them. Here is John Bradshaw. All right, we got a full slate here. Good afternoon, everybody. You're here for landlord-tenant court. My name is Judge Middleton. I get to reside in this courtroom. The law says that I have to advise you of your rights as a tenant in a landlord-tenant proceeding before we begin. Meg, I mentioned this last week. We got a note from the Judicial Tenure Commission that some judges were not advising defendants of their rights at these landlord-tenant proceedings, that tenants were complaining. So it is mandatory and it can be tedious at times, but it's important that I tell you what your rights are. So for all the defendants that are here, I think they're all non-payment of rent cases today. You have a right to hire an attorney to represent you. If you cannot afford one, a legal aid attorney may be available to assist you. We are fortunate enough to have a legal aid attorney here with us on the live feed today. If she can't represent you, she may be able to give you some advice if necessary. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or file a written demand within 5 days and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, that's called Community Action Agency, a housing assessment and resource agency, that would be Neighborhoods, Inc., or if you're a veteran, you may be eligible for some veterans resources. We sent that information to you with the original packet with the summons and complaint. You do not need a judgment against you to receive assistance from the places listed above. Copy of the summons and complaint are sufficient, but frankly, we've got more need than we've got resources, and there isn't enough money to go around, but hopefully you maybe could find some help. You may be able to reach an agreement with the landlord by going through mediation. Both parties are interested. Court can help set that up with our local community dispute resolution group. You may be eligible to reach an agreement with the landlord that means the case would get dismissed, in which case they would file something called a conditional order of dismissal, and it would probably be filed by the plaintiff. The esteemed John Bradshaw is here on behalf of Vista Point versus Weiderman, and that would be Corey Weiderman. We got two people on the screen there. Who's with us?
Billy Joe.
And Corey.
All right. And Chrissy Collins, are you the manager of this complex?
Currently, I am.
All right. They changed managers, they changed names. According to my notes, rent's $875 per month, and it was delinquent for several months. At the time of filing, it was $1,850. Mr. Bradshaw, what's the current delinquency?
So the current amount due, Your Honor, through the month of October is $1,925 in rent. The court costs are $200.50. Can you refresh my recollection as to your allowable late fee?
$40 a month.
All right, so I'll reduce that amount by $60.
I get $2,065.50.
Perfect.
All right, Mr. and Mrs. Weiderman, the law requires that you pay the rent or you'll be subject to being evicted. This is a first initial hearing. The law requires that I adjourn this matter at least 7 days. Now, when we reconvene, it will be November, and another month's rent will be due at that time. Do you guys have a plan to try to get caught up, or what's your situation?
Called earlier and talked to, I believe it was Christy. And we have, what did I say we had, Corey?
13.
I have 1390. I wrote it down. I had 1395 and I talked to the guy at Salvation Army and he said that if we had 1350, he would pay 500 of what we owed. But they
All right,
were
well, that's a good start. Now, let's talk a little bit more about this. If we go to next Monday, it would be November 3rd and another month's rent would be due. The only thing that'll cure this is paying the entire amount of the arrearage. But if you have 1395 plus 500, that's 1895, which is close to what's due. It's about,
well,
180. Then if we add another 875 for November, plus 2065, plus another $40 late fee, it would be 2,980.
well, on mine, it only says that our rent is 1850 is what we owe. That's what it says on our eviction notice.
Well, that was filed in September. 1850 is what was owed as of September. It's now November or October and November. So there's 2 more months. And so the total is going to be more than that because your rent just continues to accrue as each new month starts. But you're making a good start. You're making a good dent on this. The law requires that I adjourn this 7 days. That would be November 3rd. That's next Monday. And we're already quite busy, but.
Well, what I would hope to have happen, since they do have a substantial amount, and I'll talk with Ms. Collins, but that we would contact them and enter into a conditional dismissal, giving them the benefit of the extra week because it'll be in the next week, and try to come up with a conditional dismissal that allow them to pay that sometime in November.
All right.
And, okay.
All right. Now, well, that would take us to Monday, November 3rd at 2:15. Does that work?
Yeah.
Yes.
Yeah, and again, if we have the conditional dismissal in front of you and filed, Your Honor, would we need to appear?
No.
Okay, great.
So do you have their contact information, Ms. Collins?
You have their
Yes.
email, Chrissy?
Yes, I have their information.
Great.
All right. They're going to contact you and discuss this. I mentioned something in my instructions about a conditional order of dismissal. They could dismiss this case conditionally on some sort of a plan for you to get caught up with the rent. You're making a pretty substantial dent in this. I say this almost every week. It's easier for the landlord to keep a good tenant in there than to move one out and move another one in. But let's see what happens. So right now it's set for a continued hearing next Monday at 2:15. If a conditional order is filed, nobody needs to appear. Otherwise, you need to come back and we'll discuss it further. I would give you 10 days from November 3rd to pay the balance of the rent or be subject to being evicted. So November 13th is kind of looming in the distance, in the near distance, if that's such an oxymoron. So Mr. Bradshaw's going to get a hold of you. They're going to discuss a potential conditional order of dismissal. If that's entered, that would take care of it. If it isn't, we'll address it next Monday at 2:15. Do you have any questions? All right, you're good to go. Thank you. Expect to hear from Mr. Bradshaw.
Thank you.
Thank you very much.
Chrissy, I'll give you a call. Thank you, Your Honor.
So I don't want to remove the wrong party. Things jump around. All right, next we've got our V Squared Ventures. Looks like we have both Christine and Jordan Yancey here. We've got Cody and Selena are here. Jordan, are you on this one?
Yes, Your Honor.
All right, very good. And I thank you for the accounting form. It makes it so much easier. So let me make some notes here. This was a John Bush client, and sorry to say Mr. Bush is pulling out of the landlord-tenant business. He always did a very good job. But so does the Yancey firm. So I'm happy to have you guys back. We'll call it the Hardin firm. All right, I had expected to see a lot of these, and I guess maybe we will. This is V Squared Ventures versus Selena Haley and Cody Schutzow. Jordan Hardin is here on behalf of the plaintiff. One of their managing partners, Carissa Finnerman-Rarick, is here, and Selena Haley and Cody Schutzow are here. This is a new housing development put up on the edge of Centerville, which was an instant success. There were 9 units. I think there's more than that. Maybe there's 15 units of 6 apartments per building. So it's a lot of units. The rents are $1,000 or more, which is, for us, a pretty substantial rent. One thing you are doing, Ms. Rarick, I commend, is doing these sooner rather than later. You've been here with some other landlords that wait till they're 8 months behind before they file, and then it's too late to do anything about it. Ms. Haley and Mr. Schutzow, according to Ms. Hardin, what did I do with it? He gave me that wonderful accounting sheet and then I lost it. September's rent, late fee, October's rent and late fee is $2,080. Court costs of $188.69 and a water bill to the village and $80 a month for 2 dogs is $3,468.89. Is that still accurate, Ms. Hardin?
Yes, Your Honor.
What's
With the
your
note
position?
that September, November will be due.
Yes. The law requires that I continue this matter at least 7 days, which would take us to next Monday. Do you have a plan to try to get caught up on the rent, or do you plan to move?
We'd rather not move. We'd like to work something out. I do have orientation at TH this week, and we're going to try some of them resources that you were talking about earlier.
Very good. Now, as Ms. Hardin mentioned, and you heard me say in the previous case, another month's rent is going to be due by the time we're back. So you might as well add $1,040 to that, another month and another late fee. The 3,468. .89 plus 1040 to get current through November be $4,508.89. With $1,000 rent, it's not too hard to get behind. Now, the law requires that I adjourn this matter for 7 days. If you are in the process of getting some financial assistance, it could potentially be adjourned again. But theoretically, you would have 10 days from November 3rd to pay the rent or move, which would be November 13th. They do have a waiting list. Like I said, Ms. Rarick, is every unit filled?
Yes, Your Honor.
And you do have a waiting list?
I can't really say that we have a waiting list.
I bet you do. All right. Anyway, we're a lot of money in a short amount of time. September, October, November, plus late fees, plus the dog. There'll be another dog fee also, and the water bill. Did you lose your employment or something?
Yeah, a month or so, or I'd say 2 months after we moved in, just a bunch of things happened to us, and we've just been trying to claw back into the rhythm of things, and it's been kind of hard. I mean, I could speculate on, we're trying to get our kids back from CPS, and I just don't want to say anything further into it. It's just been really stressful.
All right. Well, we'll address it next week at, that will be 11/3 at 2:25.
Okay.
No, 2:20. I think that other case is gonna settle. We'll do the other one at 2:30. So we're gonna revisit this. You're free to come to the courthouse or you're free to Zoom in just like you have here. But we'll address this again next week, November 3rd at 2:20. There would also be an addition, apparently it's $40 a month per dog. So there'd be plus another $80.
It's $80 a month. There's 2 dogs.
Yeah, is it $40 per dog?
Correct.
Yeah, that's a lot. So anyway, there's another 80 onto that. 4,508, 4,588, 89, 5,600 bucks. So we'll address that further. At some point, you're going to have to determine if you can't afford to live there, you might go with Plan B and try to figure out how to move. But we'll discuss that further next week. Do you have any questions?
No.
All right, you're good to go. I'll see you next Monday afternoon.
Thank you.
Thank you, Your Honor.
All right, our next one is V Square Adventures versus David Fusion and Stephanie Shank. Christine, are you on this one?
I am, Your Honor.
All right. They aren't here. Let me make my notes here.
Stutzman would go on YouTube because what if we leave for Florida and this case is still going on?
All right, this is a claim for rent through October. Rent is $2,080. We've got attorney fee, filing fee, postage and service of $480 in costs, water bill of $480. Oh, the costs are $188.69. Total due through October is $2,748. Look, I didn't know what the service was here. Shame on me. Served by attachment. Ms. Rarick, are they still there?
I'm not sure. The neighbor said that it's pretty quiet around there, that their van is there, but they haven't heard water running or any noise in there.
Well, the law requires that I adjourn this because we don't have personal service. I can't do a default. So we'll continue to November
Your Honor,
3rd.
I would say that David was served. He declined to sign acknowledgement.
I can't tell. Let me look at the actual service, but there's no sense defaulting one and not the other.
Okay.
So we'll set it for 2:30.
I just mentioned that because Mr. Fusion told Officer Morse that Ms. Shank had already moved out, if you look at the notes.
No, let me take a look. They didn't give me a copy of that.
Oh, I'm sorry. I thought you.
I just have a note in the ROA, but I didn't actually look at the proof of service. As you know, he does a great job with it. But David Fusion, Stephanie Shank moved out per David Fusion a couple of weeks ago. No other occupants. Left a copy with David Fusion. So are you arguing that that's substituted service?
Yes, they are a couple and have children together. So I just, based on what the officers indicated, there was no other occupants there.
Ms. Bauer, you have a theory on that?
I would say that if the case is not dismissed against the defendant that's moved out, then she hasn't been personally served.
That's my fear. So I don't want to set it up. The safest thing to do is just wait. So we'll continue it. Sorry, Ms. Rarick. This will accrue another month's rent. So it'll be $1,000 plus a late fee when we convene next time. But that is probably the safest course of action. She was not served and she is on the lease. All right, we'll address this at that time. It sounds like it will be a default. And again, Christine, I appreciate the accounting breakdown sheet. It speeds things up so much and having a judgment in the file.
Yes, Your Honor. I'll do an updated sheet and an updated judgment for next week.
All right, thanks.
Thank you.
All right.
Thank you,
You're
Carissa.
good to go.
Thank you.
Thank you. All right, before we go to our general civil cases, we have one more landlord-tenant matter, and that is Terry and Larry Richmond versus Melissa Grant and Robert Grant. Melissa and Robert are here. Let me make my notes. Terry Richmond is here. This is a non-payment of rent case, rent $765 per month. At this point, Ms. Richmond, what's the arrearage?
Right at the moment, it's the rent is $662.15. Court costs of $194.41 with a balance of $856.56.
So they've made some substantial payments, it looks like.
Yes, they have.
All right, Ms. Grant, your plan is to get caught up on this?
Correct. I'm just wanting to know how much is left to pay, and then I was going to try to pay what I could on my next paycheck, which is on Halloween. And then I have a plan to keep caught up in the following months.
All right, very good. Well, we're going to continue this to November 3rd.
Okay.
At 2:30.
Okay.
Now, another month's rent will be due
Correct.
So we'll add another $765, but you paid more than $1,000.
Paid 1,800.
And so that shows good. And Miss Richmond's always willing to work with a good tenant. So we should be all right. If you paid it all off, you don't even need to be here.
Okay.
But if you've not, I want you to zoom in like you did today, and we'll address this further next Monday at 2:30.
Okay.
All right, next Monday is busier than today, but we'll make time for it.
What time was it Monday?
2:30.
2:30?
Yep.
Wasn't paying attention.
All right.
Thank you.
Thank you. All
Thank
right.
you.
Good luck. It sounds like you're gonna get this caught up.
I
Meg,
have a
that's
plan.
all we had today for landlord tenant. Terry, I'll see you next time.
Okay, I'll see you Monday or next Monday.
And thank you, Judge.
We got some general civils, I got a criminal matter and some other stuff, but and this is the part where we shift gears to general civil. Somehow I have a probation violation hearing at 3:00. Good afternoon, Ms. Francis.
Good afternoon, Judge.
Which case are you here on?
I have Orbit versus Ross.
Oh, no kidding. He usually covers all of his own cases. I didn't know you came all the way out here. You represent Mr. Chisholm sometimes as well?
We do. Yes. He's actually traveling right now, so.
All right, well, we're here.
He said that they did not object to the defendant's request, so they weren't sure why it was set for a hearing.
Say that again?
He said they did not object to the defendant's motion.
Okay.
So usually those just get entered if we don't object. So they were surprised it was set for a hearing.
Well, what happens is I often set these for a hearing. The defendant offers $15 a month on a $10,000 debt. And so then you deny it, then they file an appeal or ask for rehearing. They're proposing to pay $30 a week, which is about $120, $130 a month. And you have no objection to that?
No.
All right, well, that makes this easy. Let's see whether the defendants show up. What happens is you have a motion and a counter motion and you end up chasing your tail around. So I try to get everybody in the same place at this. I wouldn't do it if it wasn't by Zoom. And he's usually very reasonable to work with. Good afternoon, Ms. Finks. You're here also on a Sturgis Hospital case. Ms. Francis, is that the only case you got?
Yes, that is the only one today.
Okay. All right.
Is
Plaintiff has no objection
Sorry.
to $30 every week. We'll start that. December 19th.
He asked for starting 9:25. I know that's passed, but
Did they make payments starting 9/25?
no, but it looks like he's trying to do it every Thursday. So could we maybe start not this Thursday, but the following Thursday?
All right, so the following Thursday would be November
6th.
6th. He's not even here for his own motion, but if he comes, I'll tell him that you had no objection. And I entered the order as they requested. And I'll see you next time. Usually I see you in the mornings, but have a good afternoon.
You too. For Miss Fink,
Is David Scott Morton Jr. here? Why are people leaving? Huh? Get it. All right, Reinecker. Eric Stephen Reinecker, 25B149680. Good morning. Your name?
Eric Reinecker.
All right, so you're going to plead to impeding, right? Responsible or not responsible?
Responsible.
Please accept it. The original charge dismissed 150. You're all set. Have a good day. Willie Johnson the second, third rather. Willie Johnson the third, 25F 244559. Your name, sir?
Willie Johnson.
You're going to plead to no proof of insurance, right? All right. You have insurance now?
Yeah.
Okay. To the charge of no proof of insurance, responsible or not responsible. All right. I'll cut it down for you to 145. Please accept it. And then you tell me when you can pay this. You need to set up a weekly plan or are you going to pay it in full? How much? Where do you work?
I'm laid off right now.
Pay 40 per week. Beginning November 10th. Is that good?
Sure.
If you don't have the money at any time, you call the court. We'll go on Zoom. I'll give you an extension. Okay? Best of luck. Carter Ashton Gardock, 25 W840000. Your name?
Carter Gardock.
All right, Mr. Glowacki. What are you driving like this for? You're 17?
Yep.
Gonna slow down, be careful.
Yeah.
Are you a junior or senior?
Senior.
All right. Cars are not toys, okay? To the charge impeding responsible or not responsible. Please accept at 150. Thank you.
Thank you, sir.
Sergeant, I'm sorry, Lieutenant? Sergeant,
Yes,
would you remind everybody to come in? I don't know where some of these people.
yes, I was talking, Mr. Morton's in here now.
What are
He
they?
was, I think he's in the Woodhaven case, but
Yeah, there's another one that they didn't come in. Igna, if you could kind of remind those guys,
okay.
just to tell them, I don't know why anybody would not come in court, but that's fine.
Yes, Your Honor.
Thank you. David Morton, David Scott Morton Jr., 25B149594. How you doing, Mr. Morton?
Pretty good.
Your name?
Nick Morton. Scott Morton.
All right. Please be careful, will you?
Yes,
To
sir.
the charge of you're complete impeding, the speed will be dismissed, right?
Yes, sir.
To that charge, responsible or not responsible?
Responsible.
Please accept it. Speed's dismissed 155. You're all set.
Thank you.
Good luck. William Thomas Hopper, 25W840100. Good morning. Your name?
William Thomas.
So you met with the department rep, you're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible to that? All right. 175, you're all set.
Thank you, sir.
Thank you. Justin Stack. Justin Anthony Stack, 25T646137. How you doing, Mr. Stack?
Good, how are you?
Your name?
Justin Stack.
All right. You're going to plead to impeding, right?
Yeah,
For that charge, responsible or not responsible?
responsible.
You had a default entered, why?
At class 4.
Next time you got to call ahead of time, okay? You had class?
For work, yeah.
Why don't you call us ahead of time and tell us?
I forgot.
Yeah. Is this your mother? Sister?
No, I'm alone.
Okay. I forgot. I love it. To the charge impeding traffic, responsible or not responsible? You had a lot of tickets?
No.
This is your first?
Not
No.
my first ticket.
How many tickets have you had?
It's so,
A handful.
no points though.
Well, I know, because you keep coming in and getting impeding. Slow down, will you?
Yeah.
How can you forget such a thing? $200. Go sign your bond over and you're all set.
All right, appreciate it. Thank you.
Plead to some combination of F2s and F3s for a agreed sentence of 5 to 7.5. There is also some discussions that Mr. Smith may enter a plea of guilty to a different set of charges, and we're going to set this for a pre-sentence investigation and come back for sentencing in about 6 to 8 weeks. Is that accurately stated?
Yes, Your Honor. Yes, Your Honor.
So where are we, Mr. Shield?
Your Honor, I've tried to explain the offer and the situation that is on the page here, which is where my client would enter a guilty plea to counts 1, 3, 5, 7, and 9, which are 3 F3s, 1 F2, and 1 F5, which would give the court the possibility of crafting a sentence that would fall within that 4-year, 11-month time period, wherein my client would be required to serve the mandatory time of 2 years. Then we could file for judicial release, and the court could have the opportunity to put him into a community-based correction facility after the mandatory time. And then after the CBCF, he would then be eligible to be on probation, on electronic monitoring, some form of supervision by the court. And I'm trying to explain that is a very realistic possibility, given all of our discussions and given the math as to how these charges add up. My client's concern, I think, is just that entering into an open plea is somewhat scary. It's certainly more in line with what we've talked about, what we talked about in the jail last night, what we have been talking about for weeks now. But I think he just had some reservations because, quite frankly, the list of the charges and the maximum prison terms, the total number that's possible is a scary number. But I believe that we are close to him signing on the dotted line for this situation where he enters a plea today and gets a PSI, and then we come back in 3 to 4 weeks and are sentenced.
Mr. Smith, where are we at on all this?
Like my attorney said.
I'm sorry?
The second one he said.
Okay. Do you have any questions about what's going on?
Kinda. I mean, he summed it up a little bit for me. I couldn't understand why, if you guys kind of agreed to a little something, why I had to wait till sentencing to get further justification, but.
So here's where we're at in this, Mr. Smith. There is one set of circumstances under which you can get certainty in how your case is going to go, okay? And that is if you take, if you take Mr. Goodyear's offer, then 100% you're going to know what happens. That means that you're going to get a 5 to 7.5 year prison sentence. Now, what that means is the 5 to 7.5 is all mandatory time, which means that you do every day of the 5-year prison sentence. And when you get out, you're on post-release control. You also have what we call the Reagan-Tokes, or the indefinite time. So you have 5 to 7.5. That means if you don't behave yourself while you're in prison, the Department of Rehabilitation and Corrections can keep you up to 7.5 years if you don't behave yourself. Now, there's another way that this can go, is you can enter a plea of guilty to whatever other combination of charges is being offered here, but that has with it uncertainty. And the uncertainty is that I'm going to do a pre-sentence investigation, and we're going to come back here in 6 to 8 weeks for sentencing. I'm not making you any promise about what your sentence is going to be. But as Mr. Shield knows, because he's practiced in front of me before, I tend to give some indication of what I would like to see in a case. And what I like to see in cases is I like to see a punishment aspect. Mandatory prison time is the punishment aspect. And I also like to see a treatment aspect, inpatient treatment. That's what we're talking about, a community-based corrections facility, someplace like CCC, Monday, the STAR program, those 4 to 6 month programs. And I like probation, so that we can make sure that you don't go backwards in this. So if you were to enter a plea of guilty to some combination of these charges, I can never sentence you to anything less than 2 years or the 2 to 3 years mandatory prison time. I would also probably sentence you to some period of non-mandatory time with the idea that I would grant you what's called judicial release. That means I release you from the prison and I put you on probation and I give you rules to live by. If I sentence you to 4 years and 11 months, you become eligible for judicial release after, I want to say, 2.5 years. Because you would serve the 2 years you would have. After that, you would have more than 2 years remaining. So you would have to serve 180 days. So my belief is that you would become eligible for judicial release after 2 years plus 180 days. So 2.5 years. So I could grant you judicial release and put you into a program like CCC, a place like that. Then that would be another probably 4 to 6 months of incarceration. And then you might be out at the 3-year mark on probation. But you might not behave yourself while you're in the institution. You might get into trouble while you're in there, and I may not grant you judicial release. Also, something might pop up in your PSI that is very disturbing to me, and I may not want to give you judicial release at the earliest possible time. I might want to wait and give you judicial release at a later time. The issue with judicial release, why it's 4 years and 11 months, because if I give you 4 years and 12 months, that's 5 years. You have to wait until after you serve 4 years to be eligible for judicial release. So then if I had you serve 4 years and I put you into a program, you would only have 6 months hanging over your head. That's why I don't like that particular option. So you don't have a terrible record. I know you have something pending down in Hamilton County, but your record is not terrible. So that is where I'm at. You're not going to get a guarantee from me. You're not going to get a promise from me. You get in a fight in the jail between now and the time we come back for sentencing, and I may very well sentence you to all mandatory time so that I don't have to see you anymore. I used to say that's just sort of maybe a possibility in the abstract, but it happened. A few weeks ago, maybe a month ago, sent 2 guys to prison for fighting in the jail. Because if you can't get along in my jail, there's no way you're going to be able to get along out in the community. Do you have any questions of me?
No, Your Honor.
All right. Do we need to take some more time to think about this, or are we ready to go?
Ready to go.
All right. How old are you, Mr. Smith?
33.
How far did you go in school?
I got a high school diploma.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
No.
Are you a United States citizen?
Yes, sir.
Other than what I told you in open court today, has anybody made any threats, promises, or representations to get you to plead guilty to this charge against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the 3rd page there is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Shield before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to be entering a plea of guilty to aggravated trafficking in drugs, trafficking in a fentanyl-related compound, 2 counts of trafficking in a fentanyl-related compound. Those are all third-degree felonies. They're punishable by up to 36 months in prison and a $10,000 fine. You're going to enter a plea of guilty to aggravated trafficking in drugs. The maximum penalty in that is 8 to 12 years in prison. The reason it's 8 to 12 is because it's what we call a Reagan-Tokes sentence. That means that you're going to receive an indefinite sentence. You're going to receive both a minimum prison term and a maximum prison term. If you were to be sentenced to the maximum penalty in the case, I'm not going to do that, but if I were going to sentence you to the maximum penalty in this case, that means you would do 8 years and then 12. If I sentence you to the minimum sentence in the case, it would be 2 to 3. And the reason that we have that indefinite sentence is because it's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections, not me, the prison system, might keep you under certain circumstances up to the maximum penalty in the case. That is all set out here on page 2 where it says indefinite term. I can read that to you, or if you're satisfied that you understand it, we can keep going.
I understand.
All right. You're also going to be subject to a period of post-release control. That means the adult parole authority is going to be supervising you from anywhere from 18 months to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. We also have a possession of heroin, which is a 5th-degree felony, punishable by up to 12 months in prison. It also carries with it a mandatory fine in the amount of $7,500. Before we go any further, Mr. Smith, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Sir Goodyear, what are the facts?
Judge, as to count 1, on or about the 17th day of July, 2025, Warren County, State of Ohio, the defendant, Tyler Smith, did not only sell or offer to sell a controlled substance, which was a Schedule 2 controlled substance, methamphetamine, which is in violation of Section 292503A1 of the revised code. And the amount of that drug was 5 times the bulk amount as prescribed in statute. As to count 3, on about the 17th day of July 2025, Warren County, State of Ohio, the defendant did knowingly sell or offer to sell a controlled substance. And the amount of drug involved equaled or exceeded 5 grams but less than 10 grams, and that was a fentanyl or fentanyl-related compound, which is in violation of Section 292503A1 of the revised code. Count 5. On or about the 24th day of July 2025, Warren County, State of Ohio, the defendant, Tyler Smith, did not only sell or offer to sell a controlled substance, which was a Schedule 2 controlled substance. In this case, that's methamphetamine, and the amount equaled or exceeded 5 times the bulk amount, was less than 50 times the bulk amount, which is in violation of Section 292503A1 of the revised code. Count 7. On or about the 24th day of July 2025, Warren County, State of Ohio, the defendant, Tyler Smith, did not only sell or offer to sell a controlled substance, which was a fentanyl-related compound, in an amount that equal or exceeded 5 grams with less than 10 grams, in violation of Section 292503A1 of the revised code. And count 9, on about the 24th day of July, Warren County, State of Ohio, the defendant, Tyler Smith, did not only obtain, possess, or use a controlled substance, which in this case was heroin, and that's in violation of Section 292511A of the revised code.
And the counts that he's pleading guilty to, they're non-merger counts, right?
That is correct. So
okay.
The others would merge, yes.
Mr. Shield, anything on those facts?
No, Your Honor.
Mr. Smith, did you hear those facts? Is that a yes?
Yes, sir.
Do you admit that they are true?
Yeah.
Do you understand the rights you're giving up by entering a plea?
Yes, Your Honor.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. We're going to do a level 2 pre-sentence investigation. See everybody back here in about 6 to 8 weeks. Anything else?
No, Your Honor. Thank you.
All right, that's all.
Thank you, Your Honor. Again, the F3s do not have mandatory terms. The judge can put 12 months on one out of 36, 12 months on 36 on another. 12 months, he can also run. Doesn't change the fact that he's still trying to get you that for you. This one. Okay. You want to grab that?